Good morning. Russia is hard to comprehend. I'm Pavel Horakovsky, and I started the Institute of Modern Russia in 2010 to deepen the knowledge and understanding of Russian politics and society among policymakers, experts, and journalists. Our main product was essentially analytical coverage. We were basically answering the question, what happened? Today, with the war of aggression against Ukraine raising the stakes and upping the uncertainty, the main question on people's mind is different. What will happen? What will happen if the man in Kremlin dies? What will happen if there is another armed insurrection? What will happen if the war is lost by Ukraine? Those are frightening scenarios in the US because they trigger the core concern of instability. But I believe what will happen is not the right question. With Russia now more opaque and increasingly unstable, it's a multiverse of outcomes, where a seemingly concrete grasp of the chain of command can be appended by a phone call from Belarus to negotiate with a Russian mercenary. Now, what's the question then? I believe the question is what should happen? What should happen in these scenarios? It may feel scary yet to come up with these answers. That's why I've now started the Khodorkovsky Foundation in the US to bring the top experts on Russia together to formulate a positive vision for the country's future. My job is to help you understand what should happen back there so that you can make better decisions here. We're kicking off this work with the question, what should be the structure of the Russian state? And the key to this is understanding the Russian Constitution. You're about to learn how the fundamental law of the nation was developed, what it can look like in the future, how it will impact the judiciary, and what should be its parameters for a democratic transition. A few things I want to highlight as potential topics that might surface during these discussions. The configuration of Russia's future government will hinge on the internal balance of power. Today, a prevailing misunderstanding exists both in Russia and the United States regarding what kind of a Russian government configuration is in the US interests. This misunderstanding could lead to unintended and potentially very harmful consequences. So correcting this is imperative for mutual comprehension and progress. Then there is the challenging historical narratives question. The notion that Russia is inherently aligned with autocratic rule is a myth, a very hurtful myth that we must dispel. History teaches us that societal norms and political structures are not static. Switzerland, the prominent example of direct democracy, has only granted full voting rights to women in 1970, the latest. Synchronizing perceptions and aspirations. I think that one of the crucial tasks is to align what the United States believes Russia aspires to with what Russia genuinely seeks. And understanding the desired structure of power, the rules of governance, and the conditions for Russia's reintegration back into the European mainstream civilization is essential. A fundamental issue today concerning Russia is obviously its aggression and unpredictability in international affairs. The US is often bewildered by the opaque and difficult to comprehend decision-making process of the current government, leading to more uncertainty and tension. So perhaps our discussions could emphasize the creation of mechanisms and not just commitments, because these mechanisms should ensure that both domestic and international agreements are not just promises, but are embedded in a framework that guarantees compliance and accountability. We must recognize that declarations and procedures do not always align in present-day Russia. Without a solid procedural foundation, any commitments, memoranda, treaties can be easily disregarded, as evidenced by the war in Ukraine that started 3 months after Putin confirmed that he has no intentions of challenging the borders. At this conference, we want to see if we have a consensus, if we can reach a consensus. And if there is one, we want to try and convince the stakeholders that times have changed, and we can expect that after Putin, there will be a fundamental change. We'll have to discuss what changes are realistic in Russia and desirable for Russia. We must prepare for the post-Putin era, and we must answer the question of what should happen by examining these realistic and hopefully desirable changes for all parties. There are two fundamental reasons I believe that the time for formulating this vision is now. First, crisis management and planning. If you enter a crisis without a plan in place, you'll quickly become forced into a series of mandatory tactical decisions and will simply lack the time to formulate a strategy. I think this is well understood. But the deeper problem is that you're forced to build a team around expertise of solving tactical issues, as opposed to a team of strategists. The other point that I want to make is that coalescing support for a plan is better than coalescing a support for a personality. Because a well-formulated consensus, or a plan, a strategy, a program that can have broad support can withstand the changes of political figures entering and leaving the stage. Without this vision in place, political leaders are going to be selected based on their likability, which very quickly brings us back to the personalistic and inherently authoritarian model. So our mission is to create a robust framework for Russia's constitutional evolution and to form a working group dedicated to crafting a white paper that would reflect these discussions and deliberations. I'd like to quickly highlight the panels that we're going to have in the program. The panel number 1 that we're about to listen to and participate in is on Russian Constitution, its initial design and further development. We'll delve into the flaws, the impact of constitutional amendments, and the 2020 counter-reform. Panel number 2, the constitutional landscape of future Russia, will invite us to contemplate the constitutional landscape and explore the topics like doomsday constitution and envision a system in post-apocalyptic scenario. Panel number 3, on the Russian judiciary and the rule of law, lessons and prospects, will focus on the relationship between the Constitution, the rule of law, and examine the judicial independence in Putin's Russia. And finally, panel number 4 will address the constitutional parameters, crucial for Russia's democratic transition. A few notes on what will hopefully be a very fruitful discussion. So to make sure that we have a successful and dynamic conference, I urge everyone to actively engage. Actively engage in the discussion because your questions and insights are crucial to deepen our collective knowledge and understanding. We aim for a dialogue where ideas are shared freely regardless of whether they agree or differ from the prevailing views. So through this interaction, we can obtain new insights and progress that this conference aims to accomplish. A few acknowledgements. I'd like to thank the Kennan Institute and the Wilson Center for graciously hosting us, and in particular William Pomerantz and the whole team of the Kennan Institute for providing the support and guidance every step of the way that allowed us to put this event together. I'd like to also extend my deepest gratitude to the distinguished experts who contributed their wealth of knowledge and their time to the successful development of the program. Our planning began with discussions on the history of constitutional development, leading us to the best works on the topic and their authors, many of whom we will hear from today. Your recommendations, your hours on Zoom, and hundreds of messages on Signal shaped this event. So to each and every one, my profound gratitude. So this conference is an opportunity. It's an opportunity for you to contribute to a vision of Russia that is democratic, that's predictable, that's a constructive player on the world stage. So let's engage in these discussions with open minds and the shared commitment to a more stable future. The result could well be a roadmap for transformation. Thank you. Thank you for joining the Russia's Constitution and Democratic Transit Conference. And I would like to introduce our first panel. We have our wonderful moderator, Alexandra Vakru. We have Ekaterina Mishina, Peter Maggs, and William Pomerantz. So please welcome them for the discussion on the Russian Constitution, its initial design, and further development. Thank you.
Thank you so much, Pavel. Thomas Jefferson wrote in 1823 that a permanent constitution must be the work of quiet, leisure, much inquiry, and great deliberation. We can hardly describe the current moment as one of quiet and leisure. And in fact, it's probably never the case that constitutions are drafted in a period of quiet and leisure, but rather in a period of turmoil. I can promise, however, that the scholars at this conference and on this panel have invested a lot in the inquiry and deliberation part of Thomas Jefferson's statement. We're going to start today by looking at the Russian Constitution of 1993, its achievements and failures, as Peter Maggs put it. Ekaterina Mishina is going to get us started with the birth defects of the 1993 Constitution and how it was amended, definitely for worse, in 2020. Leon Aron, is he joining us on Zoom? He will, okay. He'll join us by Zoom to discuss elite compliance and the effectiveness of the Constitution. And Will Pomerantz is then going to talk about the way separation of powers has been treated in the Constitution. So allow me to introduce these distinguished experts, and then I'll turn the floor over to Ekaterina. Ekaterina Mishina is an independent legal scholar who received her PhD from the Institute of State and Law of the Russian Academy of Sciences. She currently serves as a professor at the Free University of Riga. Leon Aron is a senior fellow at the American Enterprise Institute. He received his PhD in political sociology from Columbia University, and his expansive work includes several pivotal books that provide in-depth analysis of Russian foreign policy, politics, and literature. Peter Maggs is a research professor at the University of Illinois College of Law and is an expert on comparative law with a focus on the Russian legal system. He's lectured globally, authored several books, and contributed extensively to intellectual property law discourse. And last but certainly not least, William Pomerantz is the director of the Kennan Institute, our host, and an expert on how law has shaped the political and economic development of Russia. He has hands-on experience in international and Russian jurisprudence to address a wide range of legal issues, from the development of Russia's constitution to human rights law to foreign investment and sanctions. So before I turn it over to Ekaterina, let me just say that we have an online audience as well. And if you have questions for our speakers, you can submit them online via email to kennan@wilsoncenter.org. That's one word, Wilson Center. Via Twitter at Kennan Institute, or at the Kennan Institute's Facebook page at any time. Please include your name and your affiliation when sending questions. Ekaterina, over to you.
Thank you so much. It's a big honor to speak here today, and thank you so much for joining us. And we really wanted this event to be a constitutional law Woodstock. Sadly, some of our colleagues, the absolutely best experts on constitutional law, could not travel from Russia by obvious reasons. Some could not travel from Europe because of the bureaucratic problems, but will be participating via Zoom. So here we are, and we'll try to give you a picture of adoption of the Constitution and its further development. And I will be speaking about the initial flaws of the fundamental law of Russia, how it was adopted in 1993. And I must make a point that for almost 3 years, the holiday, which we used to celebrate on December 12th, the day of the Russian Constitution, is not a holiday anymore. Now it's the day of remembrance of the original final constitution, because though this constitution was obviously not perfect, it was tailored as a suit for a specific Russian president, Boris Yeltsin, but at the same time, it established the principle of separation of powers, the supremacy of international law, human rights and freedoms, and the highest value, and the independence of courts and judges. At the same time, it granted enormous powers to the Russian president. But Boris Yeltsin, for whom the constitution was written, did not actually extend these powers beyond the constitutional scope of the presidential competence. But his successor took a different pattern, and that was the pattern of persistent strengthening of the power vertical, which reached its ultimate expression in the 2020 constitutional amendments. And by the power granted by these amendments, now we have the president who is literally irremovable and uncontrollable. The initial design of the 1993 Constitution also provided for the power of president, which is unsurprising because the Russian constitutional model was based strongly on the French Constitution, and it really made the president the most powerful figure in the system of powers. In the Russian constitutional model, the president is not just the strongest figure, he is the main organ of state power. And Article 10, which establishes the principle of separation of powers, interestingly doesn't mention the president, but we see him already in Article 11, which lists the organs of state power, and it includes 4 branches of power: the legislative power, the executive power, the judiciary, and the president, who is mentioned first in this list. And analysis of the text of the Constitution in its initial version leaves no doubt that the president is the main actor and the most important organ of state power. And this conclusion is also reflected in the Russian legal doctrine, and many Russian constitutionalists and legal scholars share this point of view, including, surprisingly, Valery Zorkin, the notorious Chief Justice of the Russian Constitutional Court, who made a point in his commentary to the Russian Constitution that the president de jure and de facto is present in every branch of power. Noted Russian academician Professor Vladimir Nersesyan wrote back in 1999 that the system of separation and interaction of powers established in the Russian Constitution is asymmetric and disbalanced, and it displays an obvious inclination towards the powers of the president. Nersesyan pointed out that a number of constitutional provisions indicate that the presidential power is placed above the classic triad of branches of power. And according to another prominent legal scholar, Professor Kutafin, the constitutional provision establishing that the president provides for the mutually coordinated functioning and interaction of the state power organs envisages a specific institute of presidential power which sits above other branches. And my noted colleagues, Professor Krasnov and Professor Shaplinsky, point out that by excluding the president from the triad of branches of power, the Constitution places him above this classic triad. And I must make a point that sadly this constitution is not free from the Soviet legacy. And Article 80 Part 3 provides the best example. According to this article, the Russian president determines the guidelines of domestic and international policy. And this is a very old norm which not only weakly complies with the principle of separation separation of powers, but which unfortunately drifted from the Soviet Constitution. First, it appeared in the Constitution of 1918, where it was the power of the All-Russian Congress of Soviets and the SIG, the Russian Central Executive Committee. Then we see it in the 1977 Constitution of the Soviet Union, where it was the power of the Communist Party. And in the 1978 Constitution of RSFSR, we, as amended in 1991 and 1992, that was the power of the RSFSR Congress of People's Deputies, the highest authority of state power. But this Soviet norm outlived the Soviet Union, and now this power belongs to an individual and not to collegial body of power. And this presidential power is a time bomb, because due to this constitutional design, the construction of power was stripped of balance. And now the president can dictate what to do to all branches of power, and sadly, this power was both confirmed and extended by the Russian Constitutional Court, who made this determination of guidelines of domestic and foreign policy, binding first for the Russian government and then for all bodies of state power. Also, I must note another obvious Soviet legacy is the vague definition of the process of formation of the Federation Council. Due to this vague definition, this procedure was changed many times, and actually now, due to this vagueness, we came to the point that this procedure of formation completely stripped the upper house of the Russian parliament from its representative nature, because up to 30 members of the upper house are directly appointed by the president, 7 of them for a lifetime. Russian constitution was repeatedly amended, and I cannot literally name an amendment which I think was either good or necessary. All the amendments were excessive, and some of them were disruptive. I must make a point that one of the most dangerous and disruptive amendments was made in 2014, when the best court in Russia, the High Court of Arbitration, the top economic court of the country, was eliminated. And the lawmakers who initiated this procedure wrote in the explanatory note, we are suggesting to do this in order to ensure the uniformity of application of law, and to eliminate the possibility of denial of access to justice. But it was not the merge of the courts as it was presented, both in the media and in the explanatory note. It was a hostile takeover performed by the Supreme Court of the Russian Federation. This constitutional amendment came into force in 2014, and after almost 27 years after its adoption, the Russian Constitution was amended in 2020, and it never saw such a huge set of amendments added to its text. And the initial design was disfigured completely. Putin's amendments, and I'm calling this document the Putin's amendments because it was President Putin who first declared his intention to change the constitution and then submitted the draft to the State Duma. Putin's amendments are unprecedented due to a number of factors. First, the number of the amendments, 206. 206 amendments. Compare it just to the 27 amendments made to the Constitution of the United States. Absolutely amazing, right? So these amendments were adopted by both houses, and the constitutionality of these amendments were confirmed by the Constitutional Court. And what was especially nice by the from the part of the Constitutional Court, it addressed the procedure which was used for adopting these amendments, the All Russia vote, which never existed in the Russian legislative framework before February 14th of 2020, when the president issued the presidential decree. And the Constitutional Court said, oh, yes, that was really something really new, but we needed to adopt these amendments. So we decided to use this new instrument to do that. At least that was very sincere, right? Some of the amendments are very discriminatory by their nature. First of all, the amendments on the Russian language, which was mentioned by Will Pomerantz yesterday during our morning session. Then, of course, I must make a point that the amendments confirmed that a very conservative approach towards marriage by stating that that the Constitution must ensure protection of the institution of marriage as a union of a man and a woman. And also the concept of historic truth, which appeared in the Russian public discourse several years before that, made its way to the constitutional level. These amendments also strongly affected the Russian judiciary, and the president now can initiate termination of powers of all the judges, starting from the Chief Justices of the Constitutional Court and the Supreme Court. These amendments completely destroyed the fundamental principles, such as judicial independence and irremovability of judges. And Russian legal practitioners make a point that the procedure of termination of judicial powers without any involvement of bodies of judicial community is totally disruptive and bad. These amendments also downsized the number of the justices of the Constitutional Court. They changed the procedure of submitting individual complaints to the Constitutional Court, making the life of Russian citizens even harder than it was, and absolutely outstanding constitutional developments. First, the provision from the federal constitutional law on the Constitutional Court establishing the power of the Constitutional Court to decide on the possibility to enforce decisions of the European Court of Human Rights was elevated on the constitutional level. And it was supplemented with another amendments to decide on the possibility to enforce judgments of foreign, of international or interstate courts, foreign and international arbitrations which impose obligations on the Russian Federation. That was definitely an echo of the decision of the Appellate Court of The Hague in the case of the Yukos shareholders versus the Russian Federation. So we came to the point where the Constitution, as it was amended in 2020, not just zeroed out Vladimir Putin's presidential terms. He is now the head of the executive branch. At the same time, he retains the power to dissolve the lower house of the Russian parliament. He directly appoints, following the non-binding consultations with the Federation Council, a number of force ministers, the so-called siloviki. He can remove these officials without any consultation or prior approval or coordination. He can fire the prime minister. He dissolved the State Duma in a bigger number of cases than it was initially designed in the Russian constitution. He will be the lifetime member of the Federation Council after expiration of his, 17th term of power or whatever it will be. So here we are on the 30th year of operation of the Russian constitution with the irremovable and uncontrollable president. And sadly, the Putin's constitutional amendments depict the obvious re-Sovietization trend and ruin best features of the initial version of the Russian constitution. The initial Russian constitution provided a spacious room for international legal standards in the domestic legal setting. It clarified the status of international law in Russian domestic legal system. The 2020 amendments symbolized the end of the Russia's commitments to the international community and its fundamental values. And I must make a point that in 2020, on the 27th year of its operation, Russian constitution became a member of the 27th Club, like Janis Joplin, Jim Morrison, and Jimi Hendrix. Thank you.
Thank you, Ekaterina. Now I think we have Leon Aron on Zoom.
Yes, thank you. Thank you very much. Any constitution's effectiveness is only as good as the compliance that it commands. And by that standard, by that criterion, the record of the 1993 Constitution is rather remarkably auspicious. I am particularly impressed by the two processes that were developing in parallel, which is the courts drawing on the Constitution in their decision-making on the one hand, and on the other, the compliance of the executive branch with the decisions of the courts. If you recall, the Article 125 describes the function of the Constitutional Court as that of checking and testing the constitutionality of the decisions of the executive branch, as well as the administrative acts of the parliament. And until the criminal procedural code was adopted in 2001, December 2001, the Constitutional Court essentially cleaned up or adjusted the old Soviet criminal code to comply with the Constitution. Among other things, it eliminated a number of the remnants, legal remnants of the Soviet police state, including the residence permits and residence registration, the so-called infamous propiska. Now, the lower courts, and that is just as significant, followed suit, especially after the Supreme Court's so-called instruction that enabled lower level courts to examine the constitutionality of the decisions of authorities on every level. And so the courts rushed right in, and the statistics for that period, 1993 to 1998, is that the citizens also exercised with glee their very unusual, exotic, but rather pleasant right to sue authorities at every level. There were around 91,000 of suits brought by citizens at every level. And in better than 3 out of 4 cases, the courts sided with the plaintiffs. Now, the epitome, however, of this direct confrontation between the Constitution and the authorities and the executive branch came in 2 cases. One was the trial of the naval officer, Alexander Nikitin, on charges brought by the FSB. And the charges were a high treason, that is espionage and the disclosure of the state secrets. Now, the defense based its strategy on 2 articles of the Constitution, Articles 42 and Articles 29, the first one referring to the right to truthful information about the environment, and the second one enabled or enshrined the right of Russian citizens to freely receive, pass on, produce, and disseminate information. And Nikitin was acquitted. The judge specifically said that he was acquitted because of these very strong constitutional arguments. And it is the first case, unfortunately, the last one as well, in Russian history, whereby someone was acquitted on charges of treason brought by the secret police. Now, the second most dramatic case of the clash between the constitutional law and the executive came in early February 1994, when drawing on its right or exercising its right of blanket amnesty, the Duma amnestied the leaders of the 1993 rebellion. Now, this at the time, of course, the Procurator General Alexander Kazanik, who personally was against that amnesty, upheld the law, and the pardoned men were released. And Kazanik actually resigned in process on the same day. Now, I believe that this is the first and only, again, case in Russian history, and I would bet a fairly substantial amount of money, if I had it, on the fact that probably at least in the European history as well, whereby the victors in a civil conflict granted amnesty to the leaders of the defeated side within the 4 months of the end of the conflict. Yeltsin, of course, as we all remember, was much exercised, shocked, as it was reported at the time, threatened to rearrest the pardoned men. And yet, in the end, the law, the constitutional law, as exercised by the Duma, was let stand. I think it's also relevant to our discussion that none of the pardoned men were in any way constricted in their constitutional right to participate in national politics in 2 years during the election or after the election. After the second Duma election in 1995, many entered into Duma, and Alexander Rudskoy was freely elected and then re-elected as governor of one of the central Russian regions. Thanks very much.
Thank you very much. Peter, over to you.
Thank you. The first two speakers have discussed in great detail some of the ways in which Putin changed the Constitution into something very different from what it started as in 1993. In yesterday's discussion, we looked quite a bit at the background of the development of the 1993 Constitution. Today, I would like to look at a somewhat more abstract level about the nature of the change, the nature of the process of the change, and what that might teach us for the future. Because while I think it's a very good idea to discuss a future constitution, one needs also to discuss how we get there from here. In particular, I'd like to look at a couple of basic questions. One is rapid movement versus gradual movement. Yesterday, I mentioned the unseemly lack of communication and deliberation that led to a split in the Orthodox Church in the 17th century as an example of rapid movement. Someone else mentioned the end of segregation in the United States. That was an example of a brilliant policy of slow movement by the National Association for the Advancement of Colored People, which first sued to integrate law schools and then gradually moved down the ladder and saved interracial marriage for last, so as to not only move gradually, but to gradually reform public opinion. Now I'd like to move into the Brezhnev era and another project, also to some extent based on observation of what was happening in France. The French-British consortium that produced Airbus got into a race with the Tupolev aviation complex, which was producing the Tupolev 144. And Tupolev actually, by cutting various corners, won the race. Also, I think pretty well established by some espionage as to what the Western powers were doing, some surreptitious purchase of Western equipment, and some counter-espionage by intelligence agencies trying to feed it false plans, but it was a race. Now, as we know, the Tupolev project failed spectacularly with the crash at the 1973 Paris Air Show, while the Concorde project continued on for 30 years before it was destroyed by a combination of a freak accident and the rise in fuel policies. I think what is interesting, and I would credit this to Brezhnev's relative weakness among Soviet leaders, was that when the civilian authorities tried to convince the military to buy into the project and spend defense money for a military version of the plane, the military leaders said no. They were very well informed about the technical characteristics of the plane, that it was hastily designed, a gas guzzler, and with very little capacity for moving people from one place to another. And here was a case where power was decentralized, not among the judiciary and so forth, but decentralized into power structures when there was a somewhat weakened center, and which reached a very rational decision. Now, when we look at why Putin was able to turn a constitution which seemed fairly hopeful at first into basically window dressing for a dictatorship, and we've heard from my colleagues some of the details how this was done. It's clear he adopted a slow policy, and like the NAACP, had some success in bringing along public opinion with him. There was also a mention yesterday of the lack of scholarship in Russia on the details of public opinion on the law. I'm delighted that Kathy Hendley is here, who is the foremost expert in that, not only outside Russia, but inside Russia. And I would like to look back a bit into Russian history. When I was studying in the Department of Civil Law at Leningrad State University, the most senior professor in the department was Nadezhda Veniaminova Rabinovich, who had studied at the Ryev courses for women and graduated in 1912 at a time when women were not admitted to Leningrad, or St. Petersburg Imperial University, as it was called then. I had the pleasure of studying in the university named after Zhdanov. There's rather a decline in the name. She was very outspoken, and I would like to think that she inherited some of that outspokenness and brilliance from the brilliant professor Leon Petrozhitsky, who moonlighted by being lecturing at the Ryev courses for women, and who is famed for really introducing to Russia and to some extent to the world the science of looking at what people thought about the law and not just looking at what the books said the law was. And unfortunately, that tradition was lost. In Russia, he had to flee to Poland, and the communists confiscated his research notes. But I am happy to see this somehow reappearing with Professor Hendley's work. And I think it is a very important thing if we're trying to figure out how one gets from here to there, even though the role of the public is much more limited in Russia than in many other countries. I think it can't be ignored, and it was to provide window dressing for this role that we had Putin decided to have the vote on the amendments. Now, just as the Tu-144 fell apart and crashed, so essentially did the Russian Constitution. Meanwhile, the French Constitution has been serving for many decades as the center of a vibrant democracy respecting human rights and freedoms. I think this shows that copying a design without some of the accompanying background, and in France we had well over a century and a half of liberty and equality and fraternity, which some brief deviations for Napoleon and so forth in the 19th century, by the latter part of the 20th century, had become very firmly entwined in the French consciousness. Clearly, Russian legal consciousness was much weaker. And if we look back to the weaknesses of the Constitution, one part was the legal consciousness was weaker, but the other part, which has been very important and which the other speakers have pointed out, is that the very fine principles, particularly in the first part of the Constitution, depended heavily on an independent judiciary. And that independence was sliced away very deliberately by Putin's salami tactics, as the other speakers have said. So I think we have two things to learn here. One is you often have a very hard choice between moving slowly and moving quickly. And the second is you need a combination of an independent judiciary and strong public belief in the rule of law. And if you don't have those, no matter how beautiful the language you write, it won't work. Thank you.
Well, thank you very much. I'm going to rely on the previous speakers, and they have dealt with all of the flaws of the Russian Constitution in great detail. I'm going to focus on simply one aspect of the Russian Constitution, and that is this notion of separation of powers that we have all discussed and feel that this is an important part of any constitutional reform. Now, there was a clause in the Russian Constitution, Article 10, that described the separation of powers, and it said that state power was to be divided between executive, legislative, and the judiciary, and that all these institutions should be autonomous. Most commentators focused on the second half of the clause, but I have focused more on the first half of the clause, and that is the notion of state power. In fact, that was, from my opinion, the most important part of the article. State power has never been associated with either the horizontal or vertical division of power. And in fact, this term has been associated with the unconstrained use of power by the sovereign for centuries. So in retrospect, this was the most important part of the notion of separation of powers, that it included a notion of state power and then went to the other branches. So I just want to talk about a competing concept in the Russian Constitution of state power, and that is the important concept of state unity. The preamble of the Constitution emphasized the notion of the state unity, while Article 5 talked about a uniform system of state power. President Putin expanded on this notion of unity as being the most important part of the Russian hierarchy by introducing a concept in 2020, in the new 2020 amendments, of a unified system of public power. And for good measure, he incorporated what was local self-government, which was originally deemed to be independent, into this unified system of public power. Unity, in fact, has been a long-running theme throughout Russian law and Russian history. When Russia first wrote a constitution, the fundamental laws of 1906, the first clause did not deal with the autocrat, but dealt with the Russian state and confirmed that the Russian state is one and indivisible. This first clause was followed up by a very confusing clause, however, which talked about the independence and the laws of Finland, and that they have their own legal regimen that was different from the Russian state. Indeed, what the fundamental laws emphasized was this notion of legal pluralism in the Tsarist period, that law depended on the states and the regions and not necessarily on national law. Russia always has gravitated, I think, to this notion of state power at any times of crisis. Indeed, Anatoly Chubais remarked in 2021 that the liberal informers had in mind the reforms of China to rebuild the Russian economy, but they soon discovered that the Russian state had essentially dissolved, and without a state, a gradual economic reform remained out of the question. Putin came to power in 1999 to restore the notion of the all-powerful Russian state. He said in his Millennium Message that the Russian people, it was not an anomaly to the Russian people to have a strong state, but the state was the guarantor of order and the driving source of change. Over the passing years, he basically attacked the notion of independent branches of government. He basically placed the legislative in the presidential administration, which drafted a significant number of laws. Indeed, the presidential administration is really one of the primary sources of law in Russia, as opposed to the legislature. He also relied, as all Russian rulers have relied, on the issuance of personal decrees as opposed to adopted laws. Indeed, and finally, as Katerina said, he put the executive under the general supervision of the president as opposed to the prime minister. Katerina has mentioned how Putin has weakened the independence of the judiciary, most notably the Constitutional Court. But I will just add two other reforms that have occurred. One, the 2020 amendments prohibit the publication of dissenting public special opinions. And that was what Justice Kononov was very famous for, the use of the dissenting opinions for the court. And the other major effect of the 2020 amendments was the reappointment of Valery Zorkin to a sixth term as chairman, which was clearly politically motivated and ensures that a reliable person remains at the helm of the Russian Constitutional Court, even though Zorkin is well beyond the mandatory age of retirement. So as we look kind of toward the future as to what sort of reforms are needed for constitutional reform, I think that the notion of state power, which has a long tradition, which we can trace through imperial law, Soviet law, and now post-Soviet law, that I think that one of the most important reforms that can be adopted during some sort of new constitutional conference or constitutional rewriting is to banish the notion of state power from the Russian legal lexicon. And with that, I will turn it over to questions.
Thank you to all of you. I want to point out that there are two microphones in the side. If you have a question, please go to the side of the room and state your name and your affiliation. And for those who are joining online, please submit the questions for our speaker via email to kennan@wilsoncenter.org, via Twitter @KennanInstitute, or on the Facebook page at any time, and they will make their way up to me. Include your name and affiliation as well. So while people are, please.
I have a question for Ekaterina and for William. Both of you have spent most of your time discussing probably one of the most important issues of the overwhelming concentration of power and monopolization of power of executive, just the notion of separation of power that does not actually exist, or just even the kind of movement to the used term of state power. Don't you think, I would like to invite your comments on the, maybe it's a time to move from the expression that is being used regularly, separation of power, into a slightly different term with necessary consequences for institutional building in future, separated powers. Even from the language, certainly we have in front of our eyes not only example of the Russian constitution, but the US constitution as well. And the US constitution is built on the different premises, separated power, where there's very clearly distinction between three, not branches, but three powers. So as long as this term and the concept and institutional design would be kept, so it would be a recurring problem of monopolization of power, regardless of what's called state power, public power, any other power. Instead of that, moving to the concept of separated powers, it will be not only autonomous powers, but will be probably, to some extent, independent powers. And any future design of any future documents in this constitutional law would be based on separated powers. Would you consider this as a movement in the right direction?
Thank you very much, Andrei, for your question. First of all, I must make a point that maybe in the Russian translation it will sound differently, and as in any country, and specifically as in any country which is located in the post-Soviet space, the constitution de facto can differ tremendously from the constitution de jure. So it's both important how we formulate the constitutional provisions and how they will be applied, because the constitution works directly, it applies directly. But I strongly support the idea to make the branches of power really independent, and the idea to enshrine the principle of checks and balances, not just separation of power, is that you have been talking about, right? Checks and...
I would like just to suggest to abandon separation of power fully. Not разделение властей, but разделенные власти.
I know.
Separated, разделенные, отдельные, независимые власти. In the US Constitution, it's very clear. 3 different powers, not branches of power, not ветви власти, but власти, отдельные власти. So that's an idea that I'd like to, you comment, and William is already ready for that, just to consider how to divide this power that in the Russian case is almost always monopolized.
Yes, so I agree about the question of language, and for a pre-revolutionary reference, I will turn to a speech delivered by Maxim Vinover in 1906, but he talked about the notion of what it means to have a law-based state, and he talked about the isolation of each power, so that they all can actually pursue their responsibilities. And he didn't talk about checks and balances at all, quite frankly. He talked about the need for a division between executive and judiciary, which had occurred in the judicial reforms in 1864. But he said that what was needed was a division between the executive and the legislative, and that unless the legislative branch could exercise its power completely, Russia would not transition to a rule of law state. So yes, I think that that is a very important distinction to make, and that Russian jurists have long talked about it over many decades.
Thanks, Will. I think there's a question right here in the front.
Well, more a comment than a question, but.
Could you introduce yourself?
Oh, sorry, it's Peter Solomon, University of Toronto. I want to call attention to what is often seen as one of the most important aspects of a constitution. It's what I tell my students to look at first when they open a new constitution, and it's the amending formula. How easy is it to change a constitution? How do you change the constitution? And actually, one of the things that I thought was particularly good about the Russian Constitution of 1993 is that it was a constitution that was very hard to amend, at least in structural terms. To begin with, the first two parts couldn't be amended at all without you had to have a new constitution, constitutional convention. But the amending formula for the rest of the Constitution, of course, was based on the U.S. model, right? It required qualified majorities of the two houses of the Assembly Parliament, plus majorities in 3/4 of the regional legislatures. Now, this seemed, a real challenge, very difficult to achieve. And for 20 years, there were no amendments, changes to the Russian Constitution. Then, of course, things did start to change. They changed because the reality of power was such. The vertical had reached a point where the president, in effect, controlled all those different legislative bodies. But what I wonder is actually, if someone's designing a new constitution for Russia, what amending formula would you want to use? Could anybody think of one that is better than the U.S. model one that was used in 93?
If I may, I will answer first. Okay, thank you very much, Peter, for your absolutely brilliant question. And I think that we should start from the risk assessment. Like I am a legal practitioner initially, so risk assessment is a very important part of my job, right? So the main task would be to minimize the risks of repeating this scenario of 2020, when the All Russia vote was invented specifically for simplification of the procedure of amending of the Constitution. And if you look closer to the amendments which were adopted in 2020, you will see that they were changes indirectly made to the unchangeable chapters 1 and chapters 2, the role of self-government, access to state service. There are many provisions which have been indirectly changed. The role of international law, the sacred part 4 of Article 15 of chapter 1, which is the list of fundamentals of the constitutional order of the Russian Federation, which is very energetically protected by the Russian authorities from undesirable organizations. But what was done in 2020 was an attempt to impede the exercise of fundamentals of the constitutional order. So who is the undesirable organization in this picture, right? I have a lot of questions about that. So in my book, whatever will be the scenario of the future procedure of amending of the Russian Constitution, it must be very complicated in order to avoid this chaos which was initiated and exercised and brought to the logical end in 2020.
Peter or Will, do you want to add anything?
No, I agree. And yes, Putin was able to ably get around the two first parts of the Constitution. Yep. And he didn't actually produce any amendments technically, to those 2 points. But nevertheless, he introduced a whole series of legislation and different reforms during this constitutional gathering, as it were, that basically gutted the first two parts of the Russian Constitution.
Yep.
So so going forward, I think that I agree, make it difficult to amend a future constitution. But we will also need a person at the helm of Russia who is willing to abide by the Constitution as well.
Peter?
The hardest part.
Economists talk about the famous bowl of Jell-O theory, in which if you have a bowl of Jell-O and push down in one place, it comes up an equal amount in another place. And we see this in operation in the United States, in which the only practical way of changing the Constitution is to change who's on the Supreme Court. And thus, the more unchangeable the Constitution, the more there is pressure to try to subordinate the Supreme Court to political whims. And given Russia's very bad history of judicial independence, whether pushing the process to the Supreme Court and the Constitutional Court is the way to do it, is something you just have to think about.
Thank you, Peter. Will?
And I just have one other comment. In terms of strengthening the Constitution, I think the other important reform that has to be made is Russia has to limit the power of decree, because essentially Putin's pen can actually publish a law all by itself. And it was only in late pre-revolutionary Russia that laws became were asserted above the notion of decrees. But that has always been the very important part of Russian governance, that they don't have to turn to laws, that the executive can just publish a decree that has the force of law.
Thank you. Yes, in the front, please. Sorry, and then Jill. Oh, Jill first, then Ilya.
Oh,
That's
oh,
right.
okay. Thank you very much. Jill Doherty from Georgetown University. I am not a lawyer, and already the conversation is complex for me, but I have a question. And it's kind of in the same realm. President Putin loves referenda, and he has used them in Crimea and certainly in Ukraine. What is the basis in the Constitution for holding referenda? We know they're fake, the way that he has carried them out, but nevertheless, is there a basis, some type of legal basis in the Constitution for referenda on issues? No. And I know they give the veneer of public decision-making, I guess you'd say. In a new Constitution, should any of that be changed? Thank you.
Go ahead.
Okay, thank you very much. Thank you very much for your question. Now, the referenda are not addressed in details in the Russian Constitution. There is a separate law on the referenda, which unsurprisingly was not used in 2020. So what's important to know from my view about a referenda in Russia, referenda are very popular in the authoritarian regimes because there are so many ways to play with the votes, and a lot depends on how you formulate the questions which you submit to the referendum. And specifically in case of the 2020 amendments, when over 200 amendments were put together in one law on the constitutional amendment, not amendments. That was the law on the amendment. So the voters had no chance to say, oh, listen, I like this amendment, I strongly dislike that one. No way. That was a yes or no. And here, I think we should look to the experience of the Basic Law of Germany, which provides for no chance of using referenda, because referenda were actively used by the Hitler's regime. And that was one of the lessons of disadvantages of the Weimar constitutional system, the Weimar Constitution of 1919. non-democratic regimes love referenda, and they know how to play with the public opinion. So I strongly believe that in the constitution of beautiful future Russia, there will be no place for referenda. I think we should, instead of inventing a bicycle, we should look at the experience, to the positive experience of our neighbors. And here Germany provides us with a beautiful experience of how lessons of the past should be learned.
Peter, do you want to add something?
Well, one technical point, in Ukraine, the referenda were generally in puppet republics set up for the purpose of having the referenda and making things look a little legal, and if you're the puppet master, you can do it any way you want.
Okay, thank you. We have a question in the front here. Please introduce yourself.
Yeah, Ilya Ponomarev, Congress of People's Deputies. So I wanted just to make clear, to sharpen your position, if you may. You were saying several times about the abuse of the Constitution of 1993. Do you think that what's happening in the country is the abuse of the Constitution, or it's a logical consequence of how it was designed from the very beginning? Because to my mind, that's the case. That was designed to be abused.
Ilya, both.
Yeah. No, and because to connect with this, because we are all thinking about a new constitution, so that means that we need to rewrite it from the scratch. What's your position, or we need to amend the current one? And connected to this, the procedure, we just touched this issue of the referendum. When this constitution was passed, half of the regions actually rejected the constitution in terms of vote. So how you would assess the legitimacy of the current text that appeared as a result of the coup and as a result of this not so perfect referendum? Thank you.
Thank you very much for the question. First of all, I totally agree with your statement that the point where Russia is now with its constitutional development takes strong roots in the initial constitutional design of the Russian constitution. And though the Russian constitutional model was borrowed from the French experience, it was not like directly borrowed. Certain things were borrowed, certain things were not. And as I already mentioned in my report, the initial design provided for the strong disbalance to the presidential powers, and that what we should avoid in the future drafting of the new constitution for Russia. So, yes, I strongly believe that the semi-presidential constitutional system, which was envisaged in the Russian constitution in 1993, provides for unlimited powers of the head of the state. And that's why the constitutional model, which was envisaged in the Constitution of the Fifth Republic of French, is usually referred to as Caesarist constitution, because it makes the French president as powerful as one of the Caesars of the ancient Rome. But surprisingly, none of the French presidents wanted to extend the powers initially envisaged in the Constitution. On the contrary, the powers were limited, including the presidential term, which is totally non-understandable from the viewpoint of the Russian political elite. How come you've got 7 years and now you make it 5? You're serious? Why? So, we are where we are now with the Russian constitutional development due to the initial constitutional design, which was dangerous and definitely not perfect. And I must confess, I voted against this constitution. I voted against this constitution mainly because of Part 3 of Article 80. The president can do anything. He can dictate his conditions to the branches of power. That should not be happening in the country. Second, the abuse of the constitution, which was happening after the Putin's rule, in the design of the so-called Putin's legalism. You definitely know that he proclaimed the dictatorship of law. after he came to power. And look where we are now. This is not the kind of legalism that we like. So we don't need such constitutional design in future Russia. And answering the last part of your question, if I'm missing something, please remind me. I really don't want Russia to find itself in the legal and constitutional vacuum. And together with my dear colleagues, Ilya Shablinsky and Irina Alibastrova, we drafted a sort of like first aid kit for constitutional development, the most necessary amendments to the initial design of the 1993 Constitution, which should be used for a short period of time within which drafters will be working on the text of the new Russian Constitution. But you just cannot just say, okay, there is no constitution. There will be no constitution for a couple of months. We'll see what will be happening. It will be fun. And after that, we'll get a new one. No. The first aid kit has been developed. So Professor Shablinsky and Professor Alibastrova will speak about this in details. Thank you.
Thank you, Katerina. I have a question from Kathy Henley in the front. Next.
So I'm Kathy Henley from the University of Wisconsin, and I want to ask a little bit more provocative question. As Peter pointed out, the actual language of the 1993 Constitution on amendments was carried over from the German Constitution, which you've said has lots of good qualities, and it did work for a while. So I'm not sure that this idea that we're inevitably going to get to where we are now with the 93 Constitution really holds up. But my question is, given that we seem to be arguing that Putin could do whatever he wanted, why didn't he just start over? Why did he go into these 206 amendments? Why not just convene all of the Putin-like thinkers and create exactly the Constitution that he wants, without this annoying provision about amendments and the other things that are, sort of problematic for him, right? And the other provocative question I want to ask you is that if you live in a country with no opposition, can you have a constitution that's going to restrain whoever the most powerful group is in that country?
Thank you. Those were provocative. Ekaterina, you've been provoked.
Okay. Kathy, thank you very much for a question. I'm not Professor Solovey. I cannot read Putin's mind, okay? And I think that since respect to the great past is a part of his policy and his propaganda, I think it was more a tactical move to give amendments to the Constitution which would completely change its nature. But still, it won't be a new Constitution. It will be an old previous Constitution, which was adopted in 1993, but amended.
But going against that is this idea we have the Stalin Constitution, the Brezhnev Constitution, the Yeltsin Constitution. Why doesn't he want, you would think the one thing that Putin would want is the Putin Constitution, right?
Oh, he's got Putin as amendments. I think it's more than enough.
That the starting over would feed into that side of Putin, right?
Oh,
Oh.
I see.
Someone else is going to answer for you. Yes.
Yeah.
Let's wait for the microphone, please. Yeah.
He didn't want to start the constitutional process because it would include the creation of what is called constitutional convention.
Constitutional Convention.
There is no law on that, so you need to write the law on constitutional convention. You need to hold elections. Everything is under revision in this moment, and because he definitely knows that under the carpet there is a very strong competition for who is really benefiting what. I mean, of course, I mean that, and I mean I know it from GPU, yeah, because they offered this path to Putin, but it was Chuchenko who said no, because it will take too much time to prepare this and will not get us where we want to go.
I think there's a question behind you. Did you have? Sorry. Everybody else has answers. Okay.
Okay, so
Lack of opposition.
So I'm not going to answer the question on the opposition. But I just think that in terms of why Putin didn't rewrite the Constitution, I think he just targeted another Russian legal concept, which is this notion of legality and law-abidingness. So he didn't want to rewrite the Constitution, and there is a lot of tradition in Russian law about this notion of legality, of just people following the law. And that's what he wanted to emphasize, and that's what he did during his amendments.
Peter, are you going to answer Kathy's question?
I'm going to sort of
Okay.
answer the question. If you want to be a dictator and stay in power, you need a number of things. You need a good palace guard, and he got that. You need an efficient secret police who takes care of opponents. He got that. And you need enough formal power to write decrees and things, and he had that. But a good dictator over-insures himself, and part of over-insurance is going through motions of legality and trying to get public approval. A key example of this is the fake presidency of Medvedev, which only could be explained by we're going to go through the formalities rather than just using our power, which we had to play around with the term limits. And thus, I think this is a question of over-insurance. If we look at Kerensky and Trotsky, if you under-insure, it's not a good thing in Russian history.
So I want to go back to Kathy's question, actually, because I think, given how much concern there is about having a dominant branch of government in Russia, it's a legitimate question. Like, how do you deal with that if there is no opposition to quell that branch or to keep it under control? Is it possible with just the Constitution to adapt for that?
I don't think so, but right now, as you see, being a member of the opposition in Russia involves huge risks, where criminal persecution comes in the first place, right? So, right now, Russian propaganda and Russian official ideology, which is, by the way, strictly prohibited by Article 13, and absence of official or state ideology is one of the constitutional, one of the fundamentals of the Russian constitutional system. But still, in the end of 2020, there was a document approved by the Russian government which indirectly established the fundamentals of the state ideology, including historic truth, appreciation of cultural tradition of Russia, all this, famous demagoguery that you definitely know. And opposition was featured as one of the dangers to the current regime. Political pluralism, which is also one of the fundamentals of the Russian constitutional system, has been removed out of the picture. Being a member of the opposition is dangerous and punishable if you are lucky under the code of administrative offenses, if you are not lucky under the criminal code, right? So before making strong move towards decreasing the powers of the most powerful actor, we need to restore the possibility for the opposition to operate freely without taking into consideration the possible risks of criminal prosecution.
So I will invoke the 15th anniversary of the Russian Constitution, Oleg Rumyantsev, who talked about the problems of the two constitutions that were competing amongst each other in 1992-93. And he said that the only way that the 1993 Constitution was adopted was because all the parties were just exhausted, and that was the means by which the Constitution was adopted. I hope that we don't run up to the same type of political exhaustion leading up to the next Constitution. But in light of current events, I think that there is a possibility as well.
Did you want to add something?
Oh, no, thank you.
No, okay. Yes, please.
Igor Slabek, Russian America for Democracy in Russia. I have the following question. So I do understand that we will have separate discussion about future Russian constitution, and we are speaking about history right now. But what do you think? What lessons should be learned from past for better future constitution? We talked a little bit about this, but maybe more broadly. Thank you.
Okay, Russia lives in the situation when it is strongly affected by its Soviet past. And the main lesson which should be learned sounds like de-Sovietization. And what we are seeing in Russia now is the strong presence of re-Sovietization. So the concept of enemy is back. First, we've got foreign agents, then we've got undesirable organizations, now we have unfriendly countries. The concept of foreign agent was extended and extended and extended, and it was embracing more and more actors. And now we've got persons under foreign influence, which are also on the list of enemies. There are also like domestic enemies and foreign enemies. This is one problem. The other problem is what's happening with the rule of law in Russia. Because, you know, the Soviet constitutional design had no place for the rule of law, right? And what's happening in Russia now is an open violation of the fundamental principles of the rule of law, which again, one of the fundamentals of the constitutional system of the Russian Federation, vagueness of legislative wordings. Look at this language. That's exactly how it was like instructed, how it was happening in early Soviet years. Vladimir Lenin, in his letter to Dmitry Kursky, the Narcom of Justice, the Minister of Justice, was writing, wordings should be broad and flexible, and judges will determine the limit of application of this wording. So judicial discretion and arbitrary law enforcement, here we are. So what's happening now is vague definitions, like the high treason. Article 275 of the Criminal Code. Look at the wording, how it was amended in 2012. Now, almost anyone can be prosecuted and sent to penal colony for up to 25 years for almost everything. Look at the details of the guilty verdict of Vladimir Karamurza. He was sentenced to 25 years for participation in 3 international conferences. How about that? So, de-Sovietization should include getting back to the key principles of the rule of law, getting back to real separation of power, how it was envisaged in the initial design of the Russian Constitution, because initial design didn't have only like bad points, but there were also some obvious advantages, like the role of international law and definitely separation of powers, though it was repeatedly questioned later, but okay, so we must learn from the past. Path dependence is a very important thing. History matters. And I think that the task number 1 is now to stop the re-Sovietization trend. Disproportionality of punishment. Yesterday's sentence of Sasha Skachelenko. Come on, 7 years for changing price stickers. Do you remember the law on 3 spikelets of 1932? 10 years for picking up several spikelets on the kolkhoz field? It's back. It's coming back. So we must not only learn from the past. First, we must learn what was happening in the past. And we must take precautions. And there is another thing which is sometimes missed by the legislators and legal practitioners, but it's regulatory impact of the new legislation. When we are drafting new norms, we must keep in mind how these norms will be applied. I'm apologizing for the long answer, but the question was very
It's
interesting.
okay. It asked for a long answer. Will, did you want to add something? You get the last word here. And then
Okay, so in terms of what we can learn from Russian history and in terms of drafting of fundamental laws and so forth, I think that what is the great disadvantage for Russia is this notion that it was, and especially it was true in 1917, the notion of dual power, that power was distributed amongst many different sources of law, and that there was no ability to have a single source of law. And so going forward, I think that if indeed Putin proves himself mortal, we will have to figure out how Russia makes that transition and doesn't really go back to notions of dual power or the notion of federalism that meant that they had to have 40 plus individual agreements between the regions and the center. That Russia will have to deal with this notion of dual power in any sort of post-Putin regime.
All right. I've also been informed, actually you don't have the last word, but Leon Aron, who's listening in, may want to answer some of these questions. Or not. Do you know if he has some answers? No, we don't know.
Hold on. Here I am.
Speak. Yeah.
Thank you very much. The general
Right. Okay.
comment
Well, it
is
looks like
that-
he's already taken the coffee break that we're about to have.
No, I'm still
Please,
here.
yeah, we all understand. We have a very quick break now, 15 minutes at
This is
11
very
o'clock.
strange.
We'll come back
Okay,
for the second
goodbye.
panel, but please join me in thanking our first panelist for a very interesting conversation.
Hello, everyone, dear friends, colleagues. We go to the second session, to the second panel of the conference, because we have a kind of broadcast, I just want to tell our online audience that if you have questions to the speakers, you can submit questions via email, cannon@wilsoncenter.org, Wilson Center as one word, or via Twitter, Cannon Institute, or Cannon Institute Facebook page at any time. And please kind of mention your name and affiliation when sending questions. Now I will introduce our panel, which is half present here, half of the panel will join us via Zoom. Vladimir Pastukhov is a renowned Russian political philosopher and constitutional scholar. He's a visiting fellow at St. Anthony's College and the University of Oxford. He authored several books and over 200 scholarly articles on constitutional law and political science. Dr. Pastukhov is one of the authors of the report Constitutional Crisis in Russia and How to Resolve It by the Institute of Modern Russia. Irina Alibastrova, who will join us via Zoom, is a renowned Russian legal scholar. She was a department head at Russian University of Justice. She's Doctor of Law, and one of the major subjects of her interest is social solidarity and constitutional law, and both in Russian and international perspectives. Ilya Shablinsky, who will also join us via Zoom, is a professor at Free University of Riga, and before that, of course, in Moscow. And he's he authored a number of books on articles and constitutional law and constitutional theory, as well as a history of state and law. Elena Lukyanova, she's also a famous Russian constitutional scholar. She serves as co-rector of the Free University of Riga and is a lawyer with significant career in public service and academia. She's also a professor at the Moscow State University and Higher School of Economics, where she contributed to the fields of constitutional and municipal law. Ariel Cohen is a non-resident senior fellow at the Atlantic Council Eurasia Center. He is a Tufts alumni, and he wrote 6 books and numerous articles on the issues of Russia, international relations, and security issues. So, starting this panel, which where we will try to discuss kind of particular problems that must be addressed by a future constitution of Russia, and probably continuing some of the issues that have been touched at the first panel. I engaged with Vladimir Petukov first, asking him to start our discussion.
Я ничего не включаю.
Yep.
Спасибо большое за приглашение. Я приношу свои извинения, но с тех
Thank you
пор,
very much for your invitation. But I have to apologize that one of the reasons why Berezovsky lost his suit to Abramovich, he wanted to impress the attorneys and the court by using his English, which was not perfect. And I prefer to choose
я буду говорить по-русски, учитывая, что у нас есть перевод.
speaking in Russian because we have interpretation, and I'm going to give a fairly short presentation. Despite some time limitations, I'd like to give you some personal history here. I think it might be interesting, and it may be in the interests of our today's meeting. In 93, 94, the years that we are talking about, my friend Vladislav Zubov, at the time, he unfortunately, he was a fellow at the Woodrow Wilson Center. Unfortunately, he couldn't join us today. And that's how I learned about Woodrow Wilson Center from him. He also supplied me with a questionnaire. And for the first time in my life, I tried my luck and I filled out the form. I remember how I was filling it out by hand. And there was a request for theme for the topic that I would like to explore. It was the following: inevitability of return to authoritarianism, the preconditions for irreversible, inevitable return to authoritarianism in Russia. And actually, I did receive a response from the Woodrow Wilson Center. At that time, the response stated that this topic was of no interest, and I had a long memory at that time. I was only 30. I got a little bit upset the way Akudjava was in Moscow when he came back there for the first time. He said I would never. I said I would never set my foot in the Woodrow Wilson Center, and I have to say that that in a sense I did fulfill my promise, because that was my first request for grant. And you see me here for the first time in 30 years. And I came here because I have another claim. And I'd like to make a statement that will be contrary to what I was saying 30 years ago. I assume that we can, with a certain level of certainty, say that post-communist Russia may either be democratic or it may not be at all. That's a dilemma we're facing at the time, and I really think that we are at a certain certain watershed, because if Russia is not democratic, then it will have no Russia. There will be no Russia at all. There will be no future. Of course, the threat of Russia's dissolution exists. It's real. in fact, is quite real.
что есть часть людей, которые
I know that some people assume that this is not a threat, it's just an option. At the same time, I think that the dissolution of Russia, especially if it goes chaotic and uncontrollable, then it will be a catastrophe, not only for Russia, and maybe not even for Russia. It will be a catastrophe for the rest of the world, and I don't think it's an option. I don't think it's something, as we say in my family, taken the size and the weight of the unicorn, his nearsightedness is not a big problem. So I think it's not as much of a problem for Russia. It's much more so a big problem for the rest of the world. And maybe people will not agree with me, but I would say to you, the Russia that is dissolving is not so serious, but the Russia that has already dissolved or fell apart, it is something much more serious. So, but I would like to just say that the dissolution of Russia is going to be not a desirable outcome. And people who are sane don't want to have this outcome for the most part. Speaking about the methods, the ways in how we can prevent it from happening, I think that there is no unified opinion on that. It is possible, maybe, to say that Russia will be prevented from falling apart by a strong hand. One could say that Russia was created to be an authoritarian state, that any other option is not possible. I think ultimately I'm a little bit late with my claim that I made in the 90s. I think today I wouldn't have received the same response from the Wilson Center. So if I were to rephrase what Dmitry Medvedev says, the center of decision-making is eventually coming to a conclusion that after Putin, ideal Russia would be when we have the monarchy, when we have the enthronement of our son of a bitch, excuse me my language, and he will create the same state as was started by Putin. That person is not going to cross any thresholds, i.e., he will maintain decent relationships with the rest of the world. Maybe this is the point of view that is frequently expressed at the gatherings similar to the one we're having now, the so-called party gatherings. If we go beyond those gatherings, we would say that the predominant point of view is that Russia is created to be an authoritarian state. And maybe I would speak in favor of that because I'd like to have stability, but I think today stability is not a solution, is not a stability, and i.e. authoritarianism is not a solution. The time has passed, and I do predict that I did predict that there would be a return to something like Putin's authoritarianism. It could have been even worse, by the way, but there's another point that it will be the decadent authoritarianism, i.e. it will be a part of the historically evolving chain of events in Russia. Probably you could say this is the ultimate stage. You could say it's a rotting stage. It is characterized by lack of stability. It cannot exist on its own without special catalysts, without stimuli. I know that some of my colleagues, professional colleagues who worked in the pharmaceutical industry, were telling me, by the way, I was also a counselor working in that field, and one knows that stabilization of the pill, of a pill, is a most important stage at in the production of medicine. You can have the best combination of chemicals and agents possible, but they will not be effective until the stable pill appears. And the problem with this authoritarian pill of Putin is that it's actually falling apart. It has been working for 500 years, and we need to have special conditions for stabilization, and maybe war is one of those conditions. So, regardless of what kind of authoritarianism we have in Russia right now, it will be always falling into war, and the war will lead to a revolution. It will be coming out of the revolution back to the authoritarianism or not. It might be pretty endless cycle. It's a cycle that is hard to stop. Yesterday we had a very fruitful discussion, and Lev Alexandrovich expressed a very smart, very wise idea that the whole problem is in Putin. Maybe everything, in principle, the format was not so bad. We just got not very lucky with Putin. I'm afraid that I stick to exactly the opposite point of view. I think the format was not that good either. So that was a bad format that inevitably gives birth to people similar to Putin. It could be Putin or it could be somebody else, regardless. But in order to undo this cycle, this looping cycle, where you have authoritarianism, war, Russia, war, revolution, authoritarianism, war, revolution. We need to figure out how to do that. And this format, I think, involves centralized power. So people are trying to, I think Peter Solomon said yesterday, the executive power in Russia is weak. It's going to fall apart. I don't know which format of work could even work. How are we going to cope without centralized power? Russia doesn't function without a centralized power. And for me, this centralized power and the way it is structured is the focus of all the problems. The only way for us to break this indefinite cycle is to break the centralized model of Moscow-driven bureaucracy. This, or you could say, vertical of power that's based on the integration of local elites and absorbing of those local elites into itself. We need to this transition is necessary from consolidated bureaucracy, from the vertical of power. When you have a single channel model, the model that you have to the model that is based on the consensus of the local elites. And without that, I think nothing will be possible. Now, what is Russia right now? It's a kind of a barrack that's actually guided and controlled by a chief thief, who is a thief in charge, who is actually he actually makes sure that everybody complies with the limits, and some rather cruel methods are used to punish the dissenters, including wet sheets. Well, so instead we need to have a multi-story, multi-apartment unit. We need this building instead of this barrack. So, well, those were my 2 minutes. Nevertheless, I think that this is the most important goal, and the way we accomplish this goal is there's multiple ways of doing it. Where do I see the problem? Main problem is that those beehives that we have received from the old times, they are not fit to be incorporated into or placed into such a story building with normal apartments. We need to increase the size of those units, of the beehives, quote unquote. Mikhail Khodorkovsky was talking about that very nicely yesterday. We need to increase the size of those cells. So those beehives need to be expanded. Otherwise, the bees are not going to come out. We need to have the kind of subregions of sorts. And without that, the federation doesn't exist. But at the same time, if we don't change those beehives, as I call them, we are risking having another problem. So because federation will fall apart. Maybe we need to have a different structure of the federation. Maybe the federation will somehow surpass and outweigh the currently existing model that will be looped on the state council or whatever you call that organ. Now, due to the limit in time, I think I will limit myself here, but I will say two truths. One is I absolutely do not believe that we can find a solution for the tasks that Russia is facing at the time. At this stage, I think we can't find any historic cases. It's not going. We're not in a situation that there is some kind of a case that we could relate to. We need to understand the constitutional principles that function in the West in order to incorporate them the best way. And the second one is it may seem today that this is some kind of a mental gymnastics that we're involved in, but I'd like to relate us to Nashville, his ideas of privatization. He actually, this idea, somebody came up with it at the end of the 70s, sitting at a private party in somebody's apartment in some pub, and then they were discussing how things are going to be. But then ultimately, when things really fell apart, despite all of those conversations, people didn't have a really clear idea. But what usually happens is, one of my friends says, the spare card in the card game is what people grab onto when they don't have a solution in the game. And I think this is what happened. We need to make sure that the card that is there on the table that somebody grabs is very good, is a good card.
Is Irina with us?
Following the logic of today's discussion, I had to give my speech at the end because I wanted to conclude what we have, sum up the process and say what happens with what Vladimir Borisovich described to us, what kind of card is going to be lying on the table. I will try. I think we need to really have Ekaterina and Irina speak about their project first. I would prefer that. Let me say something organizational at this time. We have a lab in our university called the Transition Period Lab. It's going to be nicely institutionalized.
It will have a number of different projects. I don't know who is going to pick up those cards from the table, but we will be preparing these cards. Apart from drafting legislation, we understand that the transit could be difficult and complex. Yeah, Ponomarev is in favor of a revolution, and his Congress is preparing a whole package of laws. We are going to discuss it. We're going to discuss it in one room, so to speak. Soon we're going to launch a site. But soon we're going to launch a transitional justice project. I am a daughter of the last chair of the Supreme Judicial Council,
And I know what it's like
начали работать в новом
when
государстве, нету
members of
законопроектов,
a
как это тяжело.
parliament in a new state do not
Как
have any
потом из этого
shovel-ready
получаются
laws,
законодательные ошибки.
and what
Поэтому наша
happens,
задача
how
на сегодня
very difficult mistakes are
максимально
made in
обеспечить
a
тех,
rush.
кто придет и
So we believe
легитимизируется
that
этими
those who will
проектами.
come
Это первое.
will
Второе, я
need
слушала и первую
to
часть,
have
и там было сказано,
these
что
drafts, and
России
our purpose is
не
to prepare
хватает ни
these
политической, ни
draft
правовой
laws.
культуры за
The
30
second
лет,
topic is
прошедших с
that it
момента
was mentioned that
разрушения
Russia
Союза,
hasn't able to
во-первых,
cultivate a
научились защищать свои
legislative
права,
and
во-вторых,
legal
они
culture.
частично, не
I
все,
would say
конечно,
that in
но
30 years, people
достаточно большая
learned
часть
to protect their
освоили
rights.
конституционную
And during
терминологию,
these 30
и мы
years, they
сумели, вот
also
я,
were able to
Екатерина,
learn
и
constitutional
Ирина,
terminology.
и Илья, мы
Catherine,
подготовили
I,
энное
and
количество
Irina
хороших
prepared a
юристов,
number of
которые
good
сегодня работают по
lawyers.
самым высоким международным
These lawyers
стандартам
work
верховенства права,
in
умеют
accordance
работать. Поэтому, конечно,
to the
наша
high
ситуация
standard
сегодня
of
намного проще,
the rule of law.
чем это было
So
у
our
моего отца
situation
и его
perhaps
коллег
is
30 лет
somewhat
назад.
easier than my
Тогда,
father and his
когда
colleagues
писалась
faced
Конституция
30 years
93
ago.
года, таких специалистов были
The situation
буквально
of
единицы, таких как
1993
Тамара
Constitution
Маршакова,
was
Юрий
different. There was
Тихомиров,
only
Василий
Tikhomirov,
Власихин,
Meshchakova,
Анатолий
Vasykhin,
Кононов, Ковлер.
Kononov,
Сейчас их
Kovler.
много и
There
много
were
молодых.
very few and far between
Теперь что у
specialists.
нас
Now we have
происходит? Мы
plenty.
понимаем,
Now,
и
as
вот
far
сейчас
as
будут
the
рассказывать
status of today,
коллеги о том, о чем уже упомянула Екатерина, о
my
том, что
colleagues are
они
going to describe
сделать
what
такую
Catherine
модель переходной
has already mentioned.
конституции,
The fact that they tried to
буквально
create
с
a
помощью
transitional
пинцета,
constitution
попытавшись
using sort of tweezers,
разграничить, сделать то нормальное
try
разделение властей,
to
которого
create
не хватало
the
в
separation
изначальном
of
тексте
powers that
Конституции.
was
Да?
lacking in the initial text of the
Я
Constitution.
не знаю, мне кажется, этого сильно недостаточно для
I
переходной
am
конституции,
not sure,
только
but I think it
перераспределить
is
власти. Тут очень
woefully
хорошо было
insufficient
сказано
for the
в первой
interim
части
constitution.
дискуссии о том,
In the
что,
first part of
в
our discussion,
общем-то,
somebody
дело же не
very
столько в
well
вертикали,
put it very
а дело
well.
как раз в
The matter,
горизонтали,
the crux of
откуда
the
мы
matter
будем
is not
перераспределять
only
вот
in
эти
the
функции
vertical,
для
but
того, чтобы
also
был
in the
баланс.
horizontal.
Мне
How
кажется, и
are we
мы
to
сейчас
separate
приходим к
various
этому выводу, что
functions to
начинать надо
achieve
все-таки снизу, с местного
equilibrium?
самоуправления, это
And I believe
горизонталь.
that we
И
need to
тогда
start
то, что
from the
останется
grassroots.
федеральной власти,
And then whatever is left
это будет
for the
совсем
federal
другая картина.
power
Собственно,
would be a
с
slightly
похожих
different
вещей
or
начинали
rather
Соединенные
radically
Штаты,
different picture. The
объединяя
United States started much the same
отдельные
way.
штаты в единую страну,
They were collecting
устраивая
various
вертикаль.
states and joining them
Значит, что у
into
нас на сегодняшний
a
день есть? Есть
single
проект,
structure.
который
What do we
подготовила
have
вот наши
at the
лаборатории,
moment?
наши
There is
коллеги,
a project
где они,
that was
повторяю,
prepared
с
by
помощью
our lab
пинцета
where
попытались
they
в
used
рамках того, что
tweezers.
предоставляет, какие возможности предоставляет действующая российская конституция, такая ювелирная была работа.
The basis of the current Russian constitution, they tried to redistribute powers, excluding the most egregious authoritarian elements. And they also tried to reshuffle the judges, creating the beginning of a judicial reform. Then there is another project of a transitional constitution where there are additional definitions, new terminology that are used to fill in the gap and the vacuum of the 1993 Constitution. But we tried to touch Articles 1, 2, and 9 to a minimum. We believe that all the effort should be put to those areas where the Constitution could be legally changed. And the Congress of People's Representatives have the draft of the law, and we believe the second article should not be changed. But it's a revolutionary version. According to it, the Congress takes the power as soon as the window of opportunity is open and holds the power until the election of a new parliament or constitutional assembly or anything else. of the sort.
Мы понимаем, что мы не сможем провести
Apart from that, we
нормальные новые
understand that
выборы
we would
по
not
тому
be able to
законодательству,
hold
которое есть на
normal
сегодняшний день в
election
Российской
based
Федерации,
on the
поэтому этот переходный
law
период
that
будет бессмысленным,
is
поэтому мы
currently
подготовили
exists,
поправки в
that currently
избирательное
exists. That's
законодательство,
why
которые эти
we
выборы
prepared amendments
позволят
to the
провести.
electoral
Плюс мы
law.
подготовили новый закон по новой
We also
концепции,
prepared
взяв
a
за
new
основу
law,
все-таки немецкую модель, хотя
taken as
адаптировали
an
ее
example the
к
German
России.
model,
Закон о политических партиях.
adapted it
Мы не
to
сможем провести
Russian
нормальные выборы,
conditions,
если
the
будут
law on political
ограничения,
parties.
те,
We would
которые
not
есть
be
сегодня в
able to hold
Уголовном
normal
кодексе, поэтому
elections if there are,
как бы
if we still
первично мы
face
расчистили уголовное
limitations from the
законодательство
criminal
от тех норм,
code. So
которые
we
не
cleaned up
позволяют
somewhat, weeded
создать
out
нормальную
the
конкуренцию
criminal law
на выборах.
and
И
took
вот этот
away
весь блок
certain
мы
conditions that do not
как бы уже
allow us
взяли,
to create normal
написана
environment for
концепция нового
elections.
закона
So we have
о
already
средствах массовой
written
информации, потому что за
the
30 лет,
concept of a
естественно,
new law
все
on
информационное
the
поле
mass
и
media.
его механизмы поменялись, и
We,
я
of
думаю,
course,
что это уже
understand,
даже
we're
не
fully
столько
aware
средства
that
массовой
the
информации,
mechanisms
сколько
of the
средства
mass
коммуникации.
media have
Концепцию мы
changed, and
написали,
it's not
будем
so much the
продолжать. Но
mass
помимо
media
этого,
as the mass
вопрос переходного
communication.
правосудия. А
And
что
apart from
делать
that,
с
we
теми
also face the
людьми,
issue of
которые
interim justice.
вольно или невольно
What do we do
фальсифицировали
with
выборы в
people
России?
who
Да?
intentionally
Что
or
делать с теми
unintentionally
членами
faked
избирательных комиссий,
elections?
которые
What do we do
учителями
with
школ, которые по
members
должности
of
вынуждены были подчиняться
precincts
директору там
and
и
the electoral
действительно
committees,
нарушать что-то? Что делать
teachers
с
and
нарушителями, другими
engineers
нарушителями
who
прав человека? Что делать с
unintentionally
бюрократами, которые
violated certain
трудились
laws? What do we
в
do with
своих
the bureaucrats,
государственных конторах,
with
поддерживая
functionaries who
незаконный
were doing
захват и
their little
удержание
thing in
власти?
their
Да?
little offices,
Это
unintentionally
часть,
supporting
конечно, их
the
ответственности, она предусмотрена
capture
Уголовным
of
кодексом,
power.
а
Part
часть
of their
нет.
responsibility is
И таких
written
людей
in the
много.
criminal
И
code,
какой
and
здесь у нас
some of it
transitional
is not
justice? Потому
delineated
что если
at
мы
all.
это не
So what kind of
проговорим, не
transitional
пройдем через
justice
себя,
are we supposed
у
to have?
нас будут
Because
повторяться все
unless
те же
we
ошибки. Это
process
должно быть
all of that, unless
официально
we
открыто всему населению.
accept our
Да, где,
mistakes,
какую
we
ответственность
are
они будут нести.
doomed to repeat the
Поэтому вот
same
этими вопросами
mistakes.
мы тоже занимаемся. Ну
So
и,
these are
конечно, огромное
also the
значение для нас
issues
играет
that we are
переходное
asking
правосудие.
ourselves. And of course, the interim justice
Война
is
рано
the
или
issue
поздно
of
кончится, так или
utmost
иначе кончится,
importance.
и
Sooner or later, the
военное
war
право
will end.
устарело за
The
70 лет
military
мира в
law
Европе,
is really old and
поэтому нам нужно
obsolete
будет
during,
привлекать
it
к
became
ответственности
old
военных
during
преступников.
70
Слава богу, у
years
нас хотя
of
бы есть
peace in
неплохие
Europe.
нормы
But of course,
Уголовного
we need
кодекса,
to bring to
которые не
justice
работают.
war
Но
criminals. Fortunately, we
военные
have
преступники
some
это одно, а
norms,
вот люди,
but
которые
war criminals
развязывали и
is
поддерживали
one matter.
агрессивную
But what
войну,
about other people who were
тут не
accomplices, who were helping to
Международный
wage
уголовный
this,
суд, ни
this war
кто-либо
of
другой
aggression,
пока, ну, то есть
nor
нужен альтернативный
international
трибунал,
court,
да.
nor
Вот этими
special
вопросами мы тоже
tribunal yet
занимаемся.
knows
С
what to do with
какими
them. We are dealing
мы
with these
сталкиваемся
matters.
проблемами? Ну вот,
So the
например,
problems now,
что
problems that we
касается
face
съезда
at the
народных
moment.
депутатов, им не
For example,
хватает
the Congress
экспертизы,
of
конечно, и
People's
специалистов.
representatives, they
Отсюда
don't have
возникают и
enough
ошибки
knowledge
в
and
их
know-how. They don't have enough
законотворчестве,
talent,
и
and
зачастую,
as a
конечно,
result, they
нужно очень
demonstrate
серьезное просвещение
mistakes in
дополнительное
their
тех
lawmaking.
членов этого съезда,
What's needed is additional education
собственно, принимают решения.
and training
Мы
for people
готовим
who
реформу
are
местного
making
самоуправления. Это
decisions.
очень
We
трудно,
are preparing the
потому что Владимир
reform
Борисович
for
правильно сказал,
the local
что
authorities, and
огромное
it's not
количество
a simple
субъектов не
undertaking.
смогут, они же
Vladimir
искусственные,
Borisovich
эти
did mention
субъекты,
a lot of
их в
constituent
Советском Союзе
entities
было
are
меньше,
artificial.
да,
There
эти
were
субъекты
fewer of them in the
искусственно
Soviet Union.
появились, те,
They,
которые не были
they were
субъектами федерациями,
artificially
обычные
created.
административно-территориальные единицы повысили в 89-м,
And in
1993 году свой статус и
1989,
стали
1993,
полноценными
they
субъектами,
simply
в общем-то,
elevated
не
their
имея для этого
status and
серьезных
became
оснований. Поэтому нам нужно будет,
fully-fledged
конечно,
constituent
укрупнение
entities.
этих
So
субъектов.
we
Я
would,
не
of
знаю, как
course,
двухуровневая
require
система, но это очень трудный
consolidation.
вопрос.
I don't know
Будет
how
ли
this
Россия
two-level system would work. It's a
разламываться,
difficult issue.
отламываться,
Whether
разваливаться, у меня
Russia is
такого
going to
ощущения
experience a collapse
всерьез
or a
нету.
creeping collapse, as somebody put it,
Роста по
I don't
простым
have
экономическим
this
причинам, потому что это очень большая
impression.
страна, у
Maybe
которой
for a
единая
very simple
энергетическая сеть, единая
economic reasons,
транспортная
because
сеть,
this is
и
a
прочие,
large country
как
with
бы
a unified
связи,
transportation
без
system,
которых
with a
какие-то регионы жить не
unified
могут. Но
power
она может
systems,
отломаться по
with
краям.
the system of
И любое
communications
уменьшение
that
этой территории, оно в целом, даже если это
benefit
по краям, на мой личный
the
взгляд, пойдет ей
peripheral
на пользу,
states.
потому что
Perhaps the
вертикаль
periphery on the margins,
зачастую
there would be a
постоянная
certain
тяга к
chipping
вертикали
away,
обусловлена
and maybe
тем,
it would be for
что
the better.
очень
The
большая
constant
территория, очень разная, и
striving
она
for a
требует
vertical
принятия
is
зачастую каких-то
well
модельных,
understood. The
централизованных
territory is, of
решений,
course,
иначе это
large,
очень
and
трудно будет
sometimes it
назвать
requires
каким-либо
centralized
вообще
decisions.
государством. Но об этом
Otherwise,
мы
it would be
тоже
very
думаем,
difficult to
и
call this
очень
chunk of
хотели бы,
territory a
чтобы
single state.
специалисты
We
конституционного права, не
think
только
about
конституционного
these
права, специалисты
problems
по
and would
переходным
very much
периодам, по
like
люстрации. Это
for
очень больной
specialists
вопрос
of
для нас сегодня,
transitional
в
law,
какой мере ее
of
надо проводить, чтобы они
constitutional
присоединились к нашей
law
работе.
to
Мы всех
join
приглашаем на
our
нашу
effort.
площадку. Мы будем
We would like
выкладывать
to
наши
invite
проекты и
and
будем
welcome
предельно
everybody
благодарны всем, кто
on
примет
our side,
участие
and we would
в их
be
обсуждении,
extremely
споре, кто
grateful
станет
to
тем самым
to
человеком, который
anyone
скажет, да,
who would
плохо
become
написали, у вас здесь ошибки. Я
who
очень
would
хочу, чтобы
arrive with a
все людей
critique,
было.
who would say, no, you
Спасибо
haven't
большое.
done a good enough job. I would like more of such critics.
And we're moving to Irina. And I think she will go into detail of this transitional, as Lena formulated, surgically prepared amendments that will allow kind of provisional constitution to function. Ирина, вы будете говорить по-русски или по-английски?
Предпочла бы
Would
по-русски.
you speak Russian or English? I prefer to speak Russian. Very good. We have a Russian panel. Thank you. I hope that this time everybody can hear me well. Please confirm that. Tell me, yes, we can hear you very well. Thank you. Colleagues, indeed, the anniversary of the current constitution is an occasion not only to reflect on the dramatic, if not to say tragic, path of its development to date, but also to think about the future of Russian constitutionalism. I hope people would forgive me that who think that it looks a little superficial against the background of what's happening. No, I think Russia should be ready for democratic transformations. I absolutely agree with the point of view that the future of Russia could only lay in the area of democratization. In order to prepare these democratic reforms so that we do not miss another chance to carry out such transformations and make them irreversible, we need a solid program. An important element of such a program should be a clear idea of the form of government. That is, the organization of supreme state power most appropriate to Russian conditions. I have thought long and hard about this matter. What form of government would be the most appropriate, would meet Russian requirements more better? And at the point, I think I'm in favor of a parliamentary republic. Yesterday, we heard some statements that lead me to believe that there is a bit of a consensus in this regard in terms of political scientists and constitutional scientists, like-minded people. But I would say that this consensus is not broad enough. Even right now, there is an opinion that with so many problems in such a large country, only centralized, if not even centralized,
system, then at least a very strong presidential system would be better. And I think it's a mistake. I think it's a very serious mistake. Today, we could preserve Russia in any way or form, and there are different opinions, only within the legal model of a parliamentary republic. And my vision of this legal model of parliamentary republic was developed and presented by a team of Russian constitutionalists within the framework of draft amendments to the 1993 Constitution. It has already been mentioned. But since researchers' task is to propose different models of development, I would like to draw attention to the experience of our neighboring post-socialist states, namely those that have moved with a greater or lesser degree of success, more or less consistently on the path of democratization. There are 21 such countries, as the economists would call them, flawed democracies of hybrid regimes out of 29 post-socialist countries. And I would say that it's a very impressive figure. And I would even call it progress. You see that it's a majority. But of course, that majority became a night horror for our authorities, and that moved them to act the way they did on February 24th last year. And only 6 of such countries have established classical parliamentary republics. 15 of them, these flawed democracies, today have forms of government that Russian researchers more often characterize as parliamentary presidential republic, while I'm inclined to call them parliamentary republics. In my opinion, it's a kind of revolution in the development of the practice and theory of checks and balances. And the main feature of this form of government, there are two main features. First is the unprecedentedly weakened presidential power and direct presidential elections. One would think it's a surprising combination and almost illogical, but the clearest manifestation of the weakening is the presidential minimal legal role in forming the government, in deciding the resignation of individual ministers and the government, and in dissolving parliament. In classical parliamentary republics, the president, with no opportunity or power to participate directly in government, is the keeper of the keys to the mechanism of good governance through participation in addressing personnel issues. But in the new post-socialist democracies, presidents are not even entrusted with these keys. Only a few of them were trusted, making their legal role akin to the status of political notaries who only certify the decisions of the parliament and partly of the government. Of course, countries with a strong tradition of personal power have a hard time getting used to such a weakened presidential institution. For example, Ukrainian President Vladimir Zelensky plays a very active role in the appointment and dismissal of ministers, a power. There is essentially a one-channel model of government, in spite of the fact that the president has the right to nominate only candidates for the ministers of defense and foreign affairs to the Verkhovna Rada. But he does that in regards to all ministers, the Minister of Culture and others. These people, these candidacies, not only coordinated with the president, he essentially proposes his people. Here's another example. Serbian President Alexander Vučić is also very active. For example, there was an announcement that the president dissolved the parliament on November 3rd, 2023. However, according to the Serbian constitution, he could not do so at his own discretion, but only at the government's request. The continued significant one-channel government was overlaying the cultural situation. In any case, the tendency toward weaker presidential power compared to classical parliamentary republic is evident. It would logically seem very problematic to combine a noticeable weakening of presidential power with direct presidential elections. However, there is a logic here. It's a bet that the president who has been unprecedentedly weakened legally will become a moral authority, relying on his statements, recommendations, and assessments.
While relying on the trust of his electorate, he can distance himself from the influences of political parties and thus compensate for the main setback, for the main problem of such a system, defending sometimes selfish party interests and sometimes substituting the interests at the national level with narrow party interests. This form of governance will be the so-called plebiscite democracy. It's a modern version, and the gist of this model is the presidents of post-socialist countries, according to their constitutions, don't have the role of political notaries. They are the conscience of the nation, and they actually are supposed to influence the power based on their respect, based on their reputation that they have accumulated over years. One could say that it's somewhat similar to parliamentary monarchies system, but on the other hand, I think it fits into the overall trend of increasing the role of the so-called soft power, soft law in society. And it has some manifestations, different forms of mediation, increasing the legal frameworks, expanding them for the solution of various, the high level of freedom of media, and all of this. So this role that has been given to the president in the post-socialist countries is played by them differently. Some of them we don't hear from at all, and in some countries there is some space for presidential opinions to be expressed. I have given you some examples, but this criticism of respectful but weak president is sensitive. It can be actually even dangerous sometimes. We see that situation in Georgia. In 2023, an attempt was made to impeach the Georgian president Salome Zurabishvili without waiting for the imminent end of her term in office, after which the president was supposed to be elected on a parliamentary basis. The corresponding reform had taken place in Georgia previously in 2017 amid disagreements between the ruling Georgian Dream Party and the previous president. Well, the thing I'm trying to say is that this case demonstrates the potential for the influence of a soft, but based on the will of voters, power of an extremely legally weakened president is high. However, the danger of having the president concentrate a huge amount of power in his hands does not exist in this situation. He can be, or she can be, a counterbalance to some of the ministers and the ruling parties. But I would say that this new parliamentary republic model, as I call it, should not be neglected. While we are preparing for democratic transformation of power in our country, for example, we need to examine how this parliamentary model functions and how the parliamentary republic could be adopted as a form. And maybe this would be the best prescription for how we're going to treat the situation and create the balance of power, both for the president, for the prime minister, and the counterbalance that will decreate. Creating the culture of party democracy can actually be the cause for instability and substituting the narrow interests of the parties to the national interests. So this is what I proposed in order to take a closer look at the experience of our neighbors and the socialist misfortune.
He's with us.
уже вместе с вами.
Да.
I'm here.
I-
I'm here.
I'm-
Yeah, Ilya, the floor is yours. Do you hear me?
Colleagues, can I begin my
Yes,
report?
yes, can, yes.
Я буду говорить по-русски, мой английский слишком
I will also speak English.
совсем не имел практики.
I
Тема
don't have a chance to practice my English. The theme of my
новая судебная
presentation is the new judiciary power in Russia and its constitutional basis. Maybe you, my colleagues, will have had a chance of the draft amendments that my colleagues and I have prepared for your consideration. We have tried to propose that for your consideration, and one of the most important tasks was the creation of a new legal basis for the enforcement of law in the Russian Federation. That's the reform. This reform has to do with the forms of governance. More specifically, we were trying to propose a new order for how the judges are going to be appointed, and also new ways to measure their responsibility. There is also a point that has to do with the renewal of the judiciary. We know what kind of justices and judges we have now and what kind of decisions they make. But that, of course, is a separate staffing issue that we are not dealing with at this time. We are talking about the legislative basis for applying pressure on the judges. So in the proposal that we have developed for this conference, we have proposed the creation of the Supreme Judiciary Council as the new body that will be in charge of federal judges' appointments. There's nothing special about this. A lot of you know about such a mechanism, which exists in many countries. There are a number of countries where there are supreme councils of justice or judges, and those provide for the independence of the judiciary, and they are in charge of the selection and the appointment of judges. I would like to briefly look at two possible scenarios. One, is how the selection and appointment of judges is happening in Russia right now, and what is so problematic about the system. And the second scenario is the order of the creation of this Supreme Judiciary Council and how it can be done. So currently in Russia, the selection of judges and checking their knowledge and qualifications is done by the Supreme Qualification Commission or panel, and it's very infrequently mentioned in the media, and practitioners don't mention it too often either. But actually, this collegium of the Supreme Collegium of Judges is very similar to the analogous organs in the European countries in form, but in content, of course, it's a completely different structure, and everything is done differently. The difference is huge. All the decisions that are made by this Supreme Qualification Collegium preliminarily, well, let me tell you that this is the instrument that is used by the administration of the president. So this qualification collegium, qualification board, is the instrument that is used by the mechanism that is used by the presidential administration. Each region has its own qualification board. I would say with a certain level of certitude that they do depend on the regional environment, but the administration of the president is taking an interest in the regional boards as well. And if they think that the regional level decisions are subject to questioning. For example, last year, a teacher from Penza, in May of last year, a teacher from Penza spoke to her 8th graders about the events such as the bombardment of Mariupol and about the destruction of the theater and other consequences. And one of the students wrote a complaint about her, and this woman was given, this teacher was given 5 years of conditional detention, which is a very soft sentence that she got. But I do know that the panel, the regional panel summoned this judge who passed the verdict, and the administration of the president was taking a keen interest in this. They were asking what was going on. I don't know whether this judge has been fired or not, but I know that she had undergone some checking. So the final decision is made by the administration of the president for all of the candidates who are reviewed by the regional panels. They send their results for further consideration in Moscow, and each of those nominees has detailed conversations with high-level bureaucrats in the big Department of Internal Policies, and they have a very, very clear goal, checking the political stance of a candidate, and maybe touching upon some minor sins such as alcohol addiction or weird behavior. I don't want to give you illustrating examples at this time. It's unnecessary, but it's kind of for that checked lightly. So there is actually a decree on the organs of judiciary that actually describes the responsibilities of the Supreme Selection Collegium, which makes those appointments. But in reality, for all appointments for the federal judge level and higher is approved by the presidential administration. So according to the Constitution, all of the federal judges are appointed by the president. And in 2020, there was another amendment that had to do with the status of the judges. According to that law, the president was endowed with the law, with the authority to also pick the chairman of the judiciary panels and their deputies. He kind of used to do that in the past as well, but that finally got reflected in the Constitution, so that nobody has even a thought of being free to do that kind of make that choice. So those. So those chairs, those chairing judges are appointed, used to be appointed for 6 years. Now, roughly by 2003, 2001 to 2003, approximately by 2003, Putin had accumulated full control over the judiciary. Well, full or not completely full, that could be debated, but I think the Yukos case is a very good example of how full it was. So I think the authority to appoint judges should be taken away from the president. I am in favor of keeping the presidential position as part of the governance structure, but he should not, or she should not have the authority to appoint judges. There should be this new organ, the Supreme Judiciary Council, which will be in charge of those appointments. So let me actually quote from the draft: people who have a stellar reputation, exemplary reputation, and vast experience of working in the government, advocacy, or educational bodies. So this is something that could be taken into consideration while making decision as to who is going to be attracted to this Supreme Council. That should be former attorneys, former legal scholars, maybe also teachers or educators. In our view, members of such a body should be people who are not members of the Judiciary Corporation. They should be people who can assess the nomination without being tied up to their corporate preferences, one could say. And of course, we need to remember what kind of judges we have right now. In some European countries, the Supreme Judiciary Councils incorporate representatives from other fields of the legal fields, including people who are defenders, public defenders, and also, by the way, some representatives of civil society, so or human rights people. How can they be elected? The procedures that have been provided for already exist. We have the All Russia Congress of Judges. That could be the organ, or it could be done again by the Supreme Council. But in any case, there should be a federal law that sets forth the procedures for the formation of this Supreme Judiciary Council. It's a separate issue how we're going to pick those candidates from the professorship teaching at law schools. I think that special conferences could be held like it's done in many countries.
Что у нас говорит мировой опыт?
Well, what does the world experience tell us? What does it show us?
В большинстве стран
The majority of countries, the old democracies, so-called old democracies,
формируются
such councils
парламентами или
are formed by the parliament or by the government. And nobody has any significant doubts. In Italy, 1/3 of this Supreme Council of Legislature is appointed, and two-thirds are actually done by the parliament. In Spain, it's a 200. 200 are appointed by the Congress of the Deputies, 10 are appointed by the Senate. But the new democracies, Romania, Poland, those organizations are formed by appointments by the judge, by the courts, and by the courts and by the human rights organizations. I don't necessarily think we need to learn from the experience of Hungary, where the appointments are done by the government, proportionate to the factions in the government. So that's the overall concept. Of course, there are details that we need to think about. For example, the numbers, the size of this or that particular organ. We need to also consider the specific nominations, specific individuals, but I don't want to elaborate on that and go to that level of details. This is the overall concept that we have. This is the overall general view of what can be done.
Thank you. And now, Ariel, I mean, with
Прекрасно. И теперь Эриэл. Thank you very much. I was thinking long and hard about choosing the language. So I decided to start in Russian, and then maybe I could transition to English. Let me try with Russian. Shall I push this button? Здесь
Законопослушный человек. Значит, я хочу всех вас тут предупредить, что я
I would like
не
to give you a fair warning. I'm not a constitutional lawyer. And the fact that I was dragged here by one of the organizers, it's really upon her head. But since I started my career in Washington by criticizing the draft constitution, and there were a draft constitution, because there were many drafts floating around. And it was back then that I wrote that these drafts are authoritarian. They distribute the powers skewed towards the president, and it will never lead to anything good, even if President Yeltsin looks so nice and warm and fuzzy, as we usually say. So I can't miss an opportunity to show off my predictive powers. I read about the federative model of government and the practice. And the federative model of government is described in two sources. One is the Federative Agreement of 1992, and the second one is the Constitution itself. And there are certain misalliances, because the Federative Agreement was not cancelled, but the Constitution, of course, has a primacy. That's the first thing. The second thing is that there are two interpretations of the government form. One way to interpret it is that, yes, there is a centralized country, There is a man in charge, it's a president, and the first thing that the president did, he used the mention in the Constitution of the issue of presidential representatives, created federal districts. There are no such thing. There is no such construct as presidential districts. And now there are, and the presidential authority rests upon them very nicely. And I think that this construct is under a serious question. The fact that you have representatives somewhere doesn't mean that you are allowed to create a federal structure and assign certain authority to this ad hoc structure. Later on, in 2022, the Constitutional Court, in its infinite wisdom, said that the highest officials of the constituent entities are accountable to the president, and that is also is not written in the Constitution, and that also begs a question. And now we also see that in comparison with 1937, when the judicial and executive power was united, essentially, now it's at least separated. But general governorship is the precedent that was used to create these federal districts that I have already mentioned. Another issue, there isn't a very clearly delineated difference written about between districts, regions, and various other territorial units. Do we need to do that? Or whether we don't need it in Russia? I'm sure that there are plenty of opinions on this matter. But it's clear that in the Northern Caucasus, the situation is somewhat different, and the units are somewhat different. They are national. Do we need a national republic in Tatarstan? If you were to ask the indigenous population, they will say yes. I visited Kazan, and they told me how they shed blood and they were knee-deep in blood, and that's how they formed their unit. So the recognition of the national roots of these republics is important. The right to have one's culture, one's language. This is something that is not welcomed in today's situation. And here's another question. Another interesting question is the issue of existing constituent entities of the federation vis-à-vis the issue of consolidation. Those in favor of consolidation are in solidarity of today's authorities, because today's authorities constantly speak about the benefits of consolidation. If you'd allow me to depart from the structural federative matters and look at it from the point of view of foreign policy, I would say that the main threat to Russia is not Ukraine or the West. I'd say it's China, because Russia, socially and economically, is lagging behind China. The question is when and how China begins to claim the territories of Siberia and the Far East. And then Xiaoping spoke about it with Shevardnadze, our Minister of Foreign Affairs. And when I spoke to Shevardnadze, he mentioned that Deng Xiaoping took him outside. They had huge maps on the tables. They looked very much like Soviet maps. And Shevardnadze said, something is missing in those maps. And he said, these maps reflect our unequal treaties. But please don't worry, so far we don't have any claims on you so far. And the fact that these maps of those injustices continue to be published in Chinese school books is something of a curiosity. And there are at least 27 million people that live to the east of the Urals, compared to Heilongjiang province, where there are only in one province 300 million people. And then there are different opinions. Who counts? But this certain disequilibrium, this misalignment, just like Chekhov's gun, is going to shoot, especially if Russia emerges from this crisis significantly weakened, and the Chinese will require certain changes according to the maps. But I've deviated somewhat. Another important issue, the management of federal units. And it's their lack of tax collecting authority. It's their inability to replenish their treasury, collecting local taxes. And it could be added value taxes, like in some states in the United States, it could be income taxes, it could be any other type of tax, but all of that is either in an embryonic state or non-existent. And that forces the constituent entities into a subservient position vis-à-vis the federal center, because the federal center has the purse and the strings to those purse. How much time do I still have? 4 minutes. I will be able to meet my prerogative and develop the issues for discussion now. Given this large territory, to manage everything manually from the old square is a little hard. And that's why, based on the American experience, I think that, and incidentally, I should say that I keep reading the Federalist papers. Of course, that puts me to sleep, but the topic is essentially the same: how to establish a federated distribution of powers and how to manage it. And it grows up from the grassroots, and then the entities join up on a volunteer basis. But we see that states have larger powers than different oblasts, and maybe we shouldn't discard this experience. How to broaden the powers of the constituent entities so that they would be in charge of their own economic development, so that they could establish their own foreign relations. That is an important issue. And by the way, there is also an issue of lack of an institution of electing governors. Right now, it goes via the Federal Assembly with a presidential veto possibility. That is a lipstick on a pig. This is not a real autonomy. It's not a real expression of the will on the part of the people who live in these regions and who want to elect their own person to be in charge. When I was discussing this issue with the people in the government, when I was still traveling to Moscow, they basically said, they quoted several reasons. First of all, we cannot trust the people. People are not to be trusted. Secondly, the corrupt local elites are not to be trusted. And besides, all of these people on the margins, just like in Vainovich book, Moscow 2042. These people are unknowable. We in the center are well known and we are good and we know what to do and we know what they need better than they know themselves. So the issue of governors' electability, the ability to elect them, is an important point. And as well as the decision of the Constituent Court to make the governors accountable to the president, that is another moment and another point. And then what else could be discussed? Defense, but also federal tax collection. The transportation system, that's right, the transportation system, emergency situations, floods, fires, yes. Then they are immediately made accountable to the president and to the president. But what about the issue of expressing the local will and choosing one's culture and language? Interesting issue to discuss. I have already mentioned taxes. Here's another thing. What percent of the GDP is collected as taxes by the federal authority and by the region rather, and given to the federal center, and what percentage could be kept by the region itself? And this is quite a serious point. I think we need to discuss it in depth. I think we need to research it, because both in Russia and in the United States, the federal center is inflated. It spends a lot of money on necessary and unnecessary matters. And I think that if people in the units in the district, in the regions, keep more of their money, they would improve the quality of life. And we could quote examples. For example, Brazil, Australia, some other countries who do not have the inflated federal center. Imagine if the United States were to move the capital to New York. Imagine the traffic jams. Even here, there are traffic jams. So the issue of the administrative capital is resolved on the same level as the issue with the Astana, a small city. So in the future, there is they think about cancel the federal districts to elect local attorneys and district attorneys, and of course, governors. And the last thing I wanted to say, the appointment, how the constitutional court judges could be also taken from under the old square building.
I would start with my own question to Irene, who studied federal aspects of the Constitution and so on. From kind of logical point of view, federation is a voluntary union, yeah? Which one...
Конституция это неоднозначно. С федеральным договором, кстати, не все республики.
It's not unequivocal in the Constitution. The federal treaty with people. Even in the Soviet Union, there was a procedure for seceding from the Union. Yes, so I wanted to ask the following question. Reassigning the government power as may happen in Putin's Russia. So this redistribution of power may require the change in the federation. Maybe not all members of that federation will want to live with each other as part of the same federation that was, artificially cut and pasted by Stalin. Some of those territories were carved in a very different, very weird way, and not only by Stalin, by others as well. So, as it is popular to say now, there's a post-colonial issue here. How we are going to handle the situation with the formation of the subjects of the federation, or using your suggestion, Vladimir, to have a two-tier system. So who is the subject of the law? People who speak the same language, who perceive themselves part of the same territorial formation. So, for example, Moscow can claim that they are separate. Well, I don't think they will want to do that, because they will want to suck the resources from the rest of the country like they are doing now. But if is there any hypothesis about how this reinstitution of the federation is going to happen, or what is going to happen in the regions where there is a compact majority or minority? Well, we talk about reinstituting. Well, then the issue of sovereignty emerges. So Yeltsin was saying, take as much as you can. Just take as much as you can, however much you want. Again, intuitively, I have a feeling that the North Caucasus will be a problem. It's becoming more and more Islamist. People of my generation, whether they're Christians or Buddhists or somebody else, the oppression or the pressure of the Soviet system was much stronger. Talking about the youth population, much younger age in Central Asia, for example, those who grew up without this pressure of the Soviet system, they are more religious and more nationalistic. So how are we going to handle the Northern Caucasus? Let's not name specific ethnicities there, but how do we think they are going to approach the enticing new boy or girl in Russia, in Moscow or St. Petersburg? How do we avoid the situation of the mass demonstrations that I observed this morning in New York, Allah Akbar, etc., et alia? So if the majority is where you are, if you produce more diamonds and oil than anybody else, you want to be independent, you want to be like United Arab Emirates or Qatar, and just be like them. I wasn't saying it at the beginning because it has nothing to do with the topic of our discussion, but we're living through very dark times, and this the fissures and the cracks that we are observing going to happen everywhere. So all of our notions, various legal concepts, sovereignty, the right for self-determination, which collide in your and get combined in your presentations. If we reorganize, then we should talk about the right for national self-determination. So if somebody in the Far East wants to say we want to live in an autonomous unit somehow closer and be closer to China, well, there used to be a Far Eastern Republic. Indeed, it existed. So who knows what's going to happen? So we need to understand the external players as well as internal players. And what we observed in the 90s, 91, 93 timeframe, for example, the attempts to increase autonomy in the Urals,
выторговать у Москвы более выгодные условия.
well, one could talk about the attempts to negotiate better conditions with Russia and maybe try to pressure them. Please check your mic.
Спасибо. Но я раз все говорили сейчас по-русски, то я вопрос задам.
Thank you very much. I will ask a question in Russian as well. My name is Ilya Ponomaryov. I have a question for Elena Lukyanova, who raised a very important topic, and what she was saying was very practical, the interaction with the Congress. And we have encountered a very serious problem in the relationship between professional jurists, constitutionalists, and the deputy corps. Each lawyer may have 3 opinions. Each deputy has at least 1 opinion. So there is this clash. So when we develop this project, these opinions can differ vastly. Because there are political interests, there is a legal construct which can be in the opposition to it. So what you have been just speaking about, the federative agreement or the Federation Treaty, we talked about this for half a day, just about this one question in the parliament. Irina, Elena, Ekaterina, all of you who are here, we respect all of you, but I have a specific question for Elena. How do you see this balance between strict legal construct or juridical control, juridical opinion and the opinion of those who are not professionals in the field, but they are the ones who express the point of view, the opinion? Well, this is not a very difficult question. It's a question for the Congress. There are always professional assistants and advisors who work with the deputies on a regular basis, and they have an opportunity to prove the point that the deputies want to make. In some of the parliaments of the world, there is even a procedure that provides for the opportunity to express the opinions in the parliament. I'm not saying that you don't have the expertise. I'm saying that maybe there is a certain insufficiency of it. There's a need for a regular, consistent work with with specific experts and also the elected officials. They need to work longer because you make decisions and pass things very quickly. When you are in a situation that a law, if the vote is positive, if the outcome is positive tomorrow, is gonna be enacted, that takes a certain level of responsibility. I don't know how it would work. The experts seem to be overburdened, overloaded with work. There's a lot of legal creation work. I'm also a member, besides my legal work, I'm a member of the anti-war committee, and I'm also a member of the expert group supporting your gathering. I'm very busy. We need to think about how to do this, but parliamentaries are not always professionals in the legal field. It's fine. He needs to be worked, or she needs to be worked with, and we need to take time to prove our point, as it happened at one of the recent sessions of Congress where I was trying to stand up for our opinion and managed to convince the parliamentary of the correctness of our position. But I wanted to warn the gathering today. The proposal from Ilya was part of the document package that was distributed to us on the eve of this meeting. Yes, definitely, we need to take into consideration the examples of and models of those countries. I know that those countries who were successful, and I know that Ilya likes the American model, which I like too. And he frequently says to me, "Why are you always saying that this is not going to work for us and that is not going to work for us?" But it worked for the United States people. And going to Federalist Papers, yes. You can read the latest Narrow Corridor, the latest book by Robinson. U.S. after the War of Independence was for independence, were in a certain situation that was actually fertile and favorable for the kind of work that had to be done on the formation of the state, and that was unique, and it's not going to exist everywhere. And of course, we are eager to correct everything as soon as possible, but I need to caution you, and it was mentioned in the first half of our discussion today that the actual model of 1993, the Axtell Constitution of 1993, I wouldn't even call it a Republican model in terms of the separation of powers. And yes, indeed, Putin was cutting, he was cutting the tail of this dog bit by bit, very eventually. But maybe now we have the advantage of having a chance of reverting to the original text of the Constitution that was good enough. It's a mistake to think that the population voted for the amendments in 2020. This kind of decision-making had nothing to do with fair and free elections, and even the referendum that was conducted earlier, only 23% people, 23% of those who were participating voted for in that referendum. So just if you don't mind, a couple of more seconds. The ability to move back to zero and start from zero and start from scratch again. Well, as I see, we only have managed to answer one question.
We'll now have a break and lunch, and we expect you back to the conference room at 1:30.
Brief bios for everyone, and then we'll get started with the presentations.
Добро пожаловать. Мы почти готовы начинать с наших презентаций. Давайте я обозначу биографию участники. Во-первых, Кэтрин Хендли. Это специализируется в области права и политики с упором на правовые и экономические реформы в странах бывшего Советского Союза. Степень доктора философии Калифорнийского университета Беркли и доктора права Калифорнийского университета в Лос-Анджелесе. Следующий докладчик Григорий Вайпан, который является российским юристом-исследователем в области права человека. Он является старшим юристом мемориала и старейшей российской правозащитной группы, также научным сотрудником по вопросам демократии в Центре анализа европейской политики в Вашингтоне. Питер Салливан, профессор Университета Торонто, почетный профессор, занимается советскими и постсоветскими исследованиями юридической системы с упором на юридическую реформу в России и Украине. Он принимает участие в работе Совета Института общественной политики и генерирует значительное количество работ, посвященных советскому российскому праву. Лорен Маккарти, доцент кафедры правоведения и политологии Массачусетского университета в Амхерсте. Она изучает взаимодействие закона и общества в рамках авторитарных режимов, а также занимается вопросами торговли людьми. И по интернету к нам присоединяется Николай Бобринский, который является исследователем правосудия переходного периода, докторантом юридического факультета Берлинского университета имени Гумбольта. Хорошо. Тогда мы сделаем презентации и начнем с Кэтрин Хендли. Спасибо. Мне кажется, что наш круглый стол будет несколько иным, нежели то, что мы видели до этого. Мы сделаем акцент на то, что происходит, как мы говорим, на театре. И я не думаю, что кто-то должен сомневаться в том, что постоянно звучит приверженность судебной независимости. Но это не означает, что суды ведут себя таким образом, чтобы обеспечить собственную независимость.
We have to distinguish between political cases and mundane cases. This is something that comes out of some of the writing on Nazi Germany, this idea of dualism, where you can talk about law having operating in different ways depending on the context. And so here, when we're thinking about judicial independence, we might want to consider how are ordinary citizens thinking about this? Are they totally obsessed with the fact that in a significant number of cases, the courts are acting in response to their political masters? Or do they pay more attention to the fact that in the vast majority of cases, people who are dealing with mundane issues are able to go to court, be fairly satisfied with what happens, and believe that when they're asked about their cases, they believe that the judges have acted independently. So we start, and we're going to have a little bit of data. So here's a public polling question that is a kind of a shocking result. So here, and I can't analyze this because we have only the descriptive results. So they're asking not are judges independent, but should they be independent? Now you would think this would be a no-brainer, right? But we see here that Russians are in fact quite divided on the question of whether or not you should even aspire to the idea of judges not being controlled by political authorities. So to me, that was very interesting. And it took me into a question about, well, how do they think about them? Not the should, but the actual reality of them. And so here I'm going to show you some results from two different surveys. One is a survey done in 2008 by Indem, and it comes out of a book project, where's Katya, that she's a co-author of. And then a 2018 survey, the Russian Longitudinal Monitoring Survey, that asked exactly the same question. And so here it is. Which of the following statements best describes your point of view? Judges in Russia are basically independent. Judges in Russia are basically under the control of representatives, and it's hard to say, right? And for any of the data people in the room, you'll know that in Russia, this hard to say issue is one that is kind of unique to Russia. And so when I did the analysis, I had to keep that in because, as we'll see, it's a significant percentage of people who aren't willing to commit. And it's hard to know what that means. Does that mean that they literally have no opinion, or does it mean that they're somewhere in the middle? But here you see that both in 2008 and in 2018, we unsurprisingly get an answer that judges are basically dependent. And that's, I think, what we would expect. So the interesting thing is, who are these people that think that judges are independent? And what are the predictors of that, right? I'll skip the methodological challenges. I don't think this is a methodological group. So I wanted to talk with you about two factors that are associated with attitudes towards courts and judicial independence. One is education, and the other is prior experience with the courts. So here, when we look at higher education, if we would run this same analysis in a country with a robust democratic system and the rule of law, you would see that people with higher education are more likely to think that their courts are independent. In autocratic countries, not just Russia, but autocratic countries in general, people with university educations are more likely to think that they are dependent, right? And we can argue, we can have lots of theories as to why this would be. Maybe they're more keeping up on politically inspired cases. Maybe they're more deeply engaged. All kinds of different stories might be behind this, but it's an interesting result. And we see this both in the 2008 results and then in the 2018 results. And in both cases, the differences are statistically significant, right? Here's the interesting thing. So you would think that given that we have this result of people who are more highly educated, that they think the courts are more dependent, you would think, okay, well, people who have legal education, they should be even more skeptical. They should be even more pessimistic about the courts, but they're not, right? We see that I have two different surveys here, again, with the same question. I did an independent thing where I was surveying students who were just finishing their legal education in 2016, and they emerged from law faculties with a pretty positive opinion of courts. So here we'll look at this. You see that here in the full sample, we have almost half of them saying that judges are independent. And then I distinguish between, and this is a little bit of, we're in the weeds a little bit here, but in most Russian law schools, you have full-time students, and then you have correspondence students. Correspondence students tend to be much older, and so you see that kind of makes sense. The full-time students are a little bit more idealistic. The correspondence students who are older are a little bit more jaded, but all of them are very different from our general sample, right? So I thought, okay, well, maybe that's just this glow of coming out of law school and you've heard all these wonderful things. You haven't seen the tawdry side of courts. So then I went to this larger, very large N survey and pulled out the lawyers. And so what you see there is that that's not what's going on. Here you see that the lawyers also, almost half of them, these would be older people, almost half of them also think that judges are independent. So this is an interesting result. It says that if you have, sort of a superficial knowledge, you're university educated but not in law, that you're going to emerge as being, skeptical. Maybe all your friends are down on the courts. I know it's hard to find anybody that when you just start talking to them about courts in Russia that has anything good to say about them. But that when you talk to people who are more engaged in the day-to-day reality of courts, can see that some of the challenges that courts are facing, can sort of weigh the pluses and minuses and maybe distinguish between, in this dualistic way, between the politicized cases and the mundane cases, that it's a very different result. And so this is something I think that needs to be tested in other authoritarian countries. Okay, so experience with courts. So this is in another study that I did. I found that when you asked court users about their experience in courts, that they were generally positive. And this is a result that often people push back on, but it stands up in the data, right? And the same thing is true here. In the 2018 survey, we find that the majority of people who had court experiences believe that their judges had been impartial, right? Now, the one thing we have to recognize here is that going to court is not a typical activity. That say in this very large survey, only about 11% of people go to court, but that's not unique to Russia. That's true pretty much everywhere. But here's what's interesting. So they had a good experience personally, but then you ask them this question about what do you think about judges and courts in general, and they come back and they're very negative about it. And so that's a puzzle, right, about why they would think that. It's consistent with what some folks who did a very similar study in China found. So it's just something to think about a little bit. So here we just see that played out here in the data. So, we can say here, though, that, what's new and interesting about what you found. It's not surprising that a solid majority believe that Russians are dependent on officials. And it's in some ways, given what the literature has predicted from other studies of authoritarian countries, it's not that surprising that people who with higher education are also skeptical about that. So the thing that's interesting and what upends our thinking about the role of education and exposure to courts is this piece of the story that nobody has looked at before, because they never had this data before, in terms of the lawyers and the people who know a lot about the legal system, because the logic would suggest that lawyers should be even more skeptical. So anyway, that's kind of the the punchline. And as I've tried to indicate as I've gone along here, I think the results make more sense when we factor in this reality of dualism, that you're always having a different, you could have depending on what the context of your case is, you could have a very different experience. I mean, the way I often put it is that the same judge can decide things very differently depending on what the context of the case is. So I'll leave it there. Thank you very much.
Thank you very much, Kathy. And we're now going to turn to Peter.
Oh, okay. That's nice. So, I'm talking about judicial reform and counter-reform. Russia's constitution of 1993 promised judicial independence, and within a few years, new laws had established on paper its key ingredients. Lifetime appointments of judges with firing only for cause and by their peers, control of judicial administration by judges, and decent funding for the courts. Most of these were actually achieved by the start of the Putin presidency. But with courts gaining in power through new jurisdiction, authorities sought to reassert control by making courts and judges more accountable. The Kozak reforms of 2002, which established disciplinary responsibility for judges and changed the makeup of the judicial qualification commissions that dealt with it, started the process of limiting judicial independence in practice and signaled to observers like retired Judge Tamara Marshakova that judicial counter-reform had begun. Over the next 2 decades, Russia experienced waves of reform and counter-reform in the judicial sphere, adopting measures that advanced judicial independence and power and ones that harmed them. Among the positive developments has been the jury trial, from its spread to most parts of the country in the early 2000s, to its later decline due to lost jurisdiction, to its recent renaissance at the district court level. Another useful change was the creation of authentic appellate review as a replacement for cassation as the first level of case review. Among the counter-reform measures, I would include the move of the Constitutional Court to St. Petersburg, the elimination of the high arbitrage courts, and changes in the Constitutional Court. But especially damaging to judicial independence was the assertion by the presidential administration of control over judicial selection and the promotion of most judges. This was achieved through the expansion of the role of the Presidential Commission on Judicial Nominations, a body that included top law enforcement officials, so that by 2017, this body was rejecting nearly a third of the judicial nominations that reached it, coming from, let's say, the Judicial Qualification Commissions and the Supreme Court. These included judges proposed for promotion to higher courts and appointment to the crucial positions of chairs of courts. In the same spirit, the firing of judges on the apex courts became a presidential prerogative with the constitutional amendments of 2020. Another critical part of the judicial reform story is the role of informal practices. While in theory judges have security of tenure, in reality they have remained dependent on the goodwill of the chairs of their courts, who could easily arrange their discipline or dismissal on a pretext. Judges who gave more than the rare acquittal, or whose decisions were reversed by higher courts, or who failed to take their chair's advice on particular cases, were vulnerable to such reprisals and might also be deprived of bonuses and benefits. Moreover, to advance to a higher court or administrative post required both a good performance record and the support of the chair, who also served as the main conduit for occasional attempts at outside influence on case outcomes. In short, the incentives shaping the conduct of judges supported conformism and discouraged creative adjudication. All the same, occasionally, individual judges did blow the whistle on attempted interference in cases, including pressure from their chairs or supervisors on higher courts. The limits on judicial independence in practice that I've been referring to were well known in Putin's Russia, and ideas for how to address them became available when, in 2016, the leader himself asked to hear about them. The Center of Strategic Research under former Finance Minister Alexei Kudrin developed proposals with the help of Maria Shklaruk and a team from the Petersburg Institute for the Rule of Law. Their recommendations included reducing the terms of court chairs from 6 years to 4, with, at the district court at least, election by their peers, the system that has existed in Ukraine since 2014, and also the transfer of many of the chairman's functions to new empowered court administrators. But their most dramatic proposal was to take the president and his commission on judicial nominations out of the process for most judicial appointments, apart from the first one where the president's participation is required by the Constitution, and transferring this responsibility to staff at the Supreme Court. At the same time, the membership of the commission would change dramatically with removal of high-ranking representatives of law enforcement and their replacements by members of the legal community. Needless to say, none of these proposals was accepted. Throughout the Putin years, judicial reform also embraced the search for efficiency and ways to help judges cope with huge and growing loads of routine cases. Simplified procedures that eliminating the hearing of evidence became omnipresent, including judicial orders, судебные приказы, in civil cases, accelerated procedure at the arbitrage courts, and in the criminal realm, the Russian version of plea bargaining, особый порядок, along with reconciliation and court fines in business-related cases. Reflection on the future of courts and judges in Russia calls for consideration of the impact of Russia's war in Ukraine. One consequence has been the reduction of dialogue about the work of courts. Even before the war, by 2012, international projects in judicial reform, a source of new ideas, had ended. And in 2021, Constitutional Court judges could no longer publish dissenting opinions. With the war, Russia pulled out of international bodies, such as the Council of Europe, and also international associations for constitutional court judges and prosecutors. Over the long haul, this isolation will mean less exposure of Russian legal officials to new thinking. Another issue is the extent to which judges in Russia face increased pressure to conform to regime expectations because of casework relating to the war. To begin, the Constitutional Court has continued its pragmatic ways in refusing to treat as unconstitutional the new administrative responsibility for discrediting the army, in a case in which my colleague Grigory Vaipan here participated. Then, judges on other courts have had to enforce new rules on business and finance, participate in the crackdown on dissent and on NGOs with foreign connections, and deal with military matters relating to recruitment, discipline, and offenses committed by soldiers. To be sure, the barrage of new laws and regulations on these matters have left judges little discretion in applying them. It is still worth asking, I think, whether any judges have resisted the new demands and been subject to discipline as a result, whether there has been an increase in judges leaving their posts, many of whom were already taking early retirement, typically in response to excessive caseloads. The judicial career may well have lost some of its appeal. For a few years, there have been reports of a shortage of candidates for judgeships, not only in the occupied regions, but also in many parts of the country. This may explain why this year judges were awarded a 30% increase in salaries and similar increases in bonuses and benefits. This at a time when the state budget was stretched to cover military demands. In sum, the situation of judges in Russia, where a successful career requires meeting regime expectations on overall performance, and occasionally in particular cases, is a classic manifestation of an authoritarian state. Ideas for changing this are available, such as those offered by the Kudrin team, and also a Liberalная Missia as well, in which Katya participated. We also heard just recently the idea that Russia should adopt the European model of judicial council, which is a whole big subject, which is not a panacea much of the time. To these, I would add a fresh approach to evaluating the performance of judges, something I can talk about later if you like. But I see little prospect of the realization of these ideas without a change in regime, not just a change in leader.
Thanks. Thank you very much, Peter. I just want to give a reminder to our audience online. If you have questions for our speakers, you can submit questions via email to kennan@wilsoncenter.org, via Twitter @Kennan Institute, or on the Kennan Institute's Facebook page at any time. Please include your name and affiliation when sending questions. Our next speaker will be Laura McCarthy.
Great. Thank you so much, Will, and thanks to everyone for coming today and for the organizers of the conference for putting this together. So my talk is going to draw on a lot of themes that we've already heard today and kind of pull them together to make one big point, which is that in thinking about the future of the Russian legal order, it is important to pay attention not only to the overarching structure of the legal system, some of the institutional design questions that we've been talking about with regard to the Constitution, but the many pathways that we can study that teach us about how law and the legal system can be weaponized using ordinary and mundane procedures. And often this happens through a lot of what Peter was just talking about, through activating existing bureaucratic incentives, through informal practices, and the sort of favorite topic of my own research, performance indicators. In other words, what I'd like to argue is that the people who implement the law matter tremendously in the way that the law works in practice. And so to kind of give an overview of a couple of examples, I'd like to talk about two tools that the Russian system has used quite effectively to implement this repressive legal regime such as it exists today. The first is essentially a two-track system of legal punishment. So all of us are very familiar with the many politicized criminal prosecutions, often based on falsified or trumped up evidence that the government has used against opponents. We need to go no further than this room to talk about that. But there is another form of violation of the law called administrative offense penalties. And one of the things that the Russian state has done very effectively over the past 10 years is amp up the penalties within that code, but also to apply them to wider and broader types of activities. So administrative offenses, for those who are not in the weeds with me, they're non-criminal infractions that are usually punishable by some kind of a fine. And in some cases, what's called administrative detention or administrative arrest, for up to 30 days. So this is a short-term time in jail, essentially. So again, this is probably a little bit more technical and in the weeds than we certainly have been beforehand, but this has been such an incredibly effective way to suppress dissent. So a couple of innovations in the Code of Administrative Offenses that I just want to touch on. The first is increasing fines. So One of the things that we're all familiar with is the increasing illegalization of protest. And again, keeping in mind that the average Russian salary is about 57,000 rubles. There's various estimates, but we're kind of in that general range a month. The fine for participating in a protest that is unauthorized, which nearly all are, has gone from 2,000 rubles to up to 300,000 rubles. And that's happened over the past 10 years. Another innovation in the administrative code meshes the administrative offense code with the criminal code in the form of 2 and 3 strikes laws. So if you violate the protest laws 3 times within 180 days, that will be grounds for opening a criminal charge. Likewise, Peter mentioned the discrediting the military law. If you do that twice and are convicted twice of that administrative offense within a year, that is also grounds for opening criminal charges. Another way that the administrative offense code has been used is to pass laws that have very similar criminal and administrative offenses. So and this creates a great degree of uncertainty in the population about whether or not the thing that they do, whether that's posting online about the war or standing outside with a sign about the war in some other form of protest, whether that's going to be a finable offense, which many people are willing to bear, or whether that's going to be a criminal prosecution that can land you in jail for many, many years. And so again, coming back to this example of discrediting the military, the companion criminal offense is disseminating knowingly false information about the Russian military, which to a non-legal ear sounds very similar. And in fact, has been used almost in exactly the same way, both criminally and administratively. The administrative offense is punishable by a fine of 30,000 rubles, possibly up to 50,000, and then more if you have some kind of official position. The second, knowing false information about the Russian military, is a criminal offense punishable at its most serious form up to 15 years in prison, which thank goodness has not yet been charged. And the point here is that people doing the exact same activity in the exact same way in 2 different regions with 2 different police stations, 2 different judges might be charged as administrative or criminal. And that creates a tremendous amount of fear. We've already mentioned in an earlier panel the case of Sasha Skochelenko, who was yesterday sentenced to 7 years in prison for disseminating knowingly false information. I have been studying the judicial decisions of the discrediting cases. There are at least 10 cases of swapping price tags that only received administrative fines, right? And so this really creates unevenness in the system. And I think this is something that, again, is happening within the context of ordinary procedural ways of doing things. You can see the exact same patterns with social media posts about atrocities in Bucha, the bombing of the maternity hospital in Mariupol. Those have been criminally charged, and they have also been administratively charged. Both have been used to target political opponents of the regime, as well as ordinary citizens, again, creating an additional level of uncertainty. And this strategy, I think, takes advantage of something that Katya Mishina mentioned earlier, the vague language in these laws that allows for every judge to make the decision and go home and sleep at night because it is legally correct. There is so much vagueness in the terminology used in these laws, and you can see when you look very closely at the decisions how they actually struggle to try to figure out at the very beginning, before they understand what they're supposed to do, how to manage this all. What is discrediting? How do we define it? One judge went to Wikipedia. Another judge went to, a regular dictionary to look it up. So these vague descriptions allow judges to come to the sort of politically palatable and correct, desirable decision on nearly all cases. And that includes things that are absurd as a person holding up a totally blank piece of paper, that you can bring in an expert and somehow that expert will say that that is discrediting the military, and the judge will say, yes, that is discrediting the military. And I think this takes advantage, to go back to the original point about the people who implement the law, this takes advantage of precisely these kinds of informal norms and pressures. Judges are concerned about reversals. They're concerned that what goes up to the appeals court, even if it's an administrative case, will be turned back and overturned. we see lots of patterns of judges who should be dismissing cases because they've exceeded the statute of limitations, instead returning those to the police to do it because they don't want that on their own record. So this is one of the ways in which we see these informal incentives playing out. And the tools of the repressive legal regime, this administrative versus criminal distinction. The second strategy of this repressive regime that I want to briefly mention is what I'm going to call, for lack of a better word, listification, which is to say the creation of lists of people and organizations to whichever increasing penalties can be applied. And the most well-known of this, and we have plenty of experts on this in the room, is the foreign agents list.
Victims.
What?
And victims too.
Yes,
That.
yes, absolutely. So this can be, this was first applied to NGOs, then it was expanded to media and journalists and citizens and informal organizations, and then affiliates of all of those people. And once you create the list, you can add fines. So you can fail to register as a foreign agent, which comes with a fine. If you continue to fail to register, it's an even bigger fine or prison. You can fail to label the materials properly, including not using the appropriate font in comparison to the other font that you are using to write the actual material. You can fail to complete the reports to the Ministry of Justice. And these fines are, of course, all increased if the news media or a person in an official position does it. After that, after you create a bunch of fines, then you can create restrictions on freedom. Anybody who's been named a foreign agent can't do a whole bunch of things. They can't run for political office. They can't hold government positions. They can't consult with the government on a variety of different things. They can't receive state funding. They can't contract with the state, and they can't do educational work with minors, which is to say they can't teach. Books from foreign agents have been removed from library shelves, and professors at universities who've been named foreign agents have been fired. So this listification takes advantage of another area of bureaucratic incentives, the incentives whereby your performance indicators are counted over time. So once you start creating a list, then you have to add people to the list, and you have to add people to the list every Friday, as it turns out in this particular situation. And so once you have that list, you can both tighten the screws on the people or organizations included there, and you drive bureaucrats who are in charge of putting people on this list to search harder and harder to find people and or organizations to put on the list. So I think sort of in sum, to go back to my original point, I think that understanding the nuts and bolts of how this regime works is actually really important, because I think it teaches us a lot about how using very standard parts of the law, things that originally look innocuous, things that originally seem limited, can then be weaponized against people who are against the regime or who the regime perceives to be against the regime. And so I think, thinking both about institutional design in the big grand ways that we've been talking about in this conference is really critical, but also understanding the incentives of the day-to-day people who will then have to implement the laws that come out of that new institutional design is really critical. I'll stop there. Thank you very much.
Thank you very much, Lauren. And we're now going to turn to Grigori.
Good afternoon, everyone. What are we going to do with all of that in future Russia with that repressive system, with that system of terror, and even more importantly, with the people who operate it? I want to move on to the issue of transitional justice. And I would like more specifically to focus on the failure of transitional justice in the early post-Soviet years as a major factor that explains why the rule of law has never taken root in post-Soviet Russia. I think it's an appropriate panel and an appropriate place to remember Galina Starovoitova, a revered human rights advocate, scholar, and a member of the Russian parliament, who was a fellow here at the Kennedy Institute in 1989. There's a Galina Starovoitova Fellowship still operating, still available here at the Kennedy Institute. She was the person who in 1992 and 1997 twice introduced a draft law on lustration in the Russian parliament. Many people, including her close associates, many people even in the human rights community, in the civil society, did not support that idea. And many people would say to her that her proposal would lead to what was called a witch hunt, a word now well aware to most people in the United States. So to those people, Starovoytova would always respond, would you rather want witches to be hunting for us? Starovoytova was murdered in 1998. It didn't live to see that history proved her right. This is exactly what happened. Witches are hunting for all of us. So in the early post-Soviet years, around 1989 to 1991, there was a very narrow, very short-lived window of opportunity to address Soviet-era crimes, the crimes of the state. And very little was done to confront those past crimes. Impunity for those crimes set the ground for persecution and abuse of power to reproduce themselves in post-Soviet Russia. So this is basically a short summary of lessons learned of the mistakes that were made, transitional justice mistakes that were made 30 years ago. And now as we're speaking about a potential future Russia, the mistakes that I believe we should not repeat. So let me briefly summarize the four aspects of that failed transitional justice project in late 1980s and early 1990s. And those four aspects are no truth finding, no investigations and prosecutions, no reparations to the victims, and no guarantees of non-recurrence. So speaking of each of those, first, there was almost no truth finding about Soviet-era crimes. Most victims remained unnamed. The only database of almost 12 million victims that we have in Russia today is a database compiled by Memorial, which only has about 3 million names, so only a quarter of people who suffered during the Soviet regime, and it's a non-state, it's a non-government run database, it's a civil effort. Most mass graves remain unidentified. It's estimated that 4 million bodies, 4 million people are buried all across Russia, their bodies scattered all across Russia in unnamed graves. In most cases, we don't know where those graves are and who those people are. Most of the archives remain closed, and in 1992, a law was adopted, a law that provided basically the personal data of any security service agents as a state secret, and that foreclosed most of the opening of the archives. Second, almost no investigations and prosecutions took place. There were some of the criminal cases that were opened in the late 1980s, but were closed in early 1990s because of the expiration of the statute of limitations. There have been a couple of remarkable examples where still living former KGB officers, retired KGB officers, were questioned by the investigators about the crimes, but then the cases were closed, those people died, investigations and prosecutions ended with nothing. No one has been brought to justice for Soviet-era crimes. Some of the results of those investigations were even made secret. The most notorious example is the Katyn massacre investigation. Third, no reparation for the victims. In 1991, the only law, the only transitional justice law that was adopted in Russia in the last days of the Soviet Union was a law on remedies for victims of political repression. And that law provides, to this day, a one-time lump sum compensation of 75 rubles, less than $1, per 1 month spent in the Gulag, with a cap of 10,000 rubles, which is about $100. There are still living survivors of the Gulag, children of the Gulag, people I represent as a lawyer, who are still unable to return to places their families were deported from. They have a right to compensation under that same 1991 law, but that compensation has never been provided to the vast majority of those people. And in general, the whole transitional justice project has been reduced to that idea of some negligible compensation to the victims, but it's just one of those four aspects that I'm mentioning. But even that aspect, the reparation aspect, has been largely unaddressed. And finally, no guarantees of non-recurrence. The Communist Party trial in 1992 at the Constitutional Court ended with nothing. And like I mentioned, the illustration draft laws introduced by Galina Starovoytova were never even discussed in the parliament. So as a result of that, not only the structures of the Soviet state remained the same, but even the same people kept running the system. So just to give you a couple of examples, Vyacheslav Lebedev, a judge on the Moscow City Court, used to jail Soviet dissidents in the 1980s for crimes that so closely resemble the crimes that Russian activists are convicted of today, like anti-Soviet propaganda, for example. In 1989, he was appointed chief judge of the Supreme Court of the Russian Federation, and he continues to be chief judge to this day. Vladimir Putin himself, not only a KGB officer in the past, but as recent research has uncovered, personally participated in the persecution of dissidents in St. Petersburg as a junior KGB officer in mid-1970s. Had that lustration law been adopted in the early 90s, he couldn't have had a career in civil service in the Russian government in the 90s with all the consequences of that. Again, it was what's important to understand and to learn of this story is that the window of opportunity was extremely narrow. It was, and there's consensus among researchers that it was confined to basically just a few months, the final months of 1991, before the economic reforms began and people lost focus on things such as transitional justice, and also the time when the Soviet system and especially the security service apparatus was at its weakest. So from August, from the failed coup to December 1991, just 4 months to accomplish something, very little was done. And sadly enough, many people in the civil society, many people in the activist community resisted the idea of a full transitional justice agenda. So to conclude, transitional justice for both Soviet era and post-Soviet Putin era crimes should be a priority in future Russia for any future government. But I have a very, we hope as a civil society that we will have an opportunity to deal with that as the Russian civil society. But I have one very specific point to make here in this audience, and that is I believe that the demonstrated commitment to transitional justice should be something that the West should be asking in any kind of negotiations with a future Russian government. In particular, any lifting of the sanctions should be conditioned upon a demonstrated commitment to transitional justice and a transitional justice agenda. And a good case in point here, I believe, in the United States is the Comprehensive Anti-Apartheid Act adopted in 1986. If you look into that act, it's an act that establishes a plethora of sanctions against the then current South African government, but it also contains a list of preconditions for the lifting of those sanctions, including not only the release of political prisoners, but also the elimination of apartheid laws and the ensuring the political participation of all South African people in the reforms. So I think it's a good example to take into account, and I'll stop here. Thank you.
Thank you very much, Grigory. Another update for our online audience. If you have questions for our speakers, you can submit questions via email to kennan@wilsoncenter.org, via Twitter @Kennan Institute, or on the Kennan Institute's Facebook page. At any time, please include your name and affiliation when sending questions. And our final speaker is going to be Nikolai Bobrinsky. Nikolai.
Thank you. My good friend and colleague Grigory Raipan offered an overview of the shortcomings of the post-Soviet transitional justice in Russia. I want to I want to take his point further and talk
Unmute.
about...
Unmute. You're muted.
And now?
Yes. Very good.
Oh, actually, thank you. My good friend and colleague Grigory Vaipan offered an overview of the shortcomings of the post-Soviet transitional justice in Russia. I want to take his point further and talk about what lessons for the future can be learned from these mistakes. I'm researching potential transitional justice after Putin and have published a book about it, so you can find more about these lessons in my book. I will start with a disclaimer. It is impossible to predict how the political landscape in Russia after Putin is going to look like. This doesn't prevent us from developing an agenda for the transitional government and for pro-democracy parties and candidates in the first free elections. Now I'm returning to the lessons from the failures of post-Soviet transition. The first lesson is that we should act quickly. As the experience of the years 1991-92 shows, the window of opportunity for launching transitional justice remains open for just a few months. This means that the most urgent measures must be implemented immediately without waiting not only for the adoption of a new constitution, but even for the outcome of the first free elections. Secondly, focus on individual responsibility and do not blame groups. The only full-fledged trial of Soviet crimes in Russia was the case of the Communist Party of the Soviet Union in the Constitutional Court. But no one was accused at that trial, and the plaintiffs and defendants argued about the collective responsibility of unspecified range of leaders and members of the Communist Party. As a result, the court could neither recognize even the most heinous crimes of the communist regime, nor name the individuals who were responsible for them. The narrative of collective responsibility should be abandoned, since it leads to the preservation of total impunity. It is necessary to bring to trial at least some key perpetrators of the state-related or systemic crimes, such as aggression, usurpation of power, state terror, corruption, and torture. Thirdly, make perpetrators speak about their crimes. Many former Communist Party members and KGB officers who never faced trial or fact-finding procedure quickly moved from insincere public commitment to human rights to denial of Soviet crimes or relativization and justification of these crimes. Agents of the regime should be encouraged to expose crimes in which they participated or which they witnessed. This can be done through granting them a relief from criminal liability in exchange for testimony, provided that such testimony is given publicly, for example, before a truth commission. The fourth lesson is to prioritize vetting the judiciary and prosecuting obstruction of justice. Grigory Vaipan has already mentioned the chief judge of the Russian Supreme Court, Vyacheslav Lebedev. This is just a striking example of a general rule. New Russia has completely inherited the judiciary from the Soviet state. In the 1991 concept of judicial reform, cherished by many liberal Russian lawyers, vetting of the judiciary was not mentioned at all. On the contrary, that concept spoke about the need to, quote, treat the members of judiciary with care, unquote. This omission should not be repeated for the second time. Judges, prosecutors, and investigators who took part in state terror should be relieved of their duties at the early stage of democratic transition. Subsequently, their activities must be investigated for suspected obstruction of justice. Those complicit in criminally violating fundamental human rights, such as freedom of speech or freedom of assembly, and those who took part in mock trials must be indicted. And finally, give victims as many reparations as possible. According to the law on rehabilitation of victims of political persecutions of 1991, one of its goals was to, quote, ensure an affordable level of compensation for damage inflicted to those victims. unquote. This clause on affordable level of compensation foreshadowed the plight of victims of communist persecutions in the new Russia. Democratic transition must include a broad program of reparations for victims of the crimes of the regime, starting from expedited release and rehabilitation of victims of state terror, amnesty for those sentenced to severe punishment for petty crime, containing a simplified procedure for recognition as victims of those who suffered from armed conflicts and torture by police and special services, and ending with generous compensations for damage to health and property and moral damage. I will conclude my presentation by repeating those 5 lessons from the post-Soviet transition for post-Putin transitional justice. Once transition starts, act quickly and implement transitional justice as early as possible. Focus on individual responsibility and do not blame groups. Make perpetrators speak about their crimes. Prioritize vetting the judiciary and prosecuting obstruction of justice, and give victims as many reparations as possible. Thank you.
Thank you, Nikolai. And again, to our audience online, if you have questions to our speakers, you can submit questions via email at kennan@wilsoncenter.org, via Twitter at Kennan Institute, or on the Kennan Institute's Facebook page. I want to deal firstly with this question of transitional justice, which is just a huge, important issue going forward. And Russians don't really know, but it had the first international tribunal dealing with transitional justice in 1917. So the Muravyov Commission basically had hearings for about 6 months about the crimes of the Tsarist state. And it was only closed down after the Bolsheviks took over. So Russia actually has an important historical tradition of transitional justice that is often not remembered. I also want to deal with the question of transitional justice. And I want to ask Grigory and Nikolai, is transitional justice going to get caught up in the war in Ukraine as well going forward? Because there are many attempts now to update the notion of the crime of aggression or crime against peace and basically charge Russia with that. And they haven't been able to do so because it's not a part of the Rome Statutes. So to what extent will transitional justice become caught up in the war in Ukraine? And the other issue that kind of the war talks about or has been raised is the question of reparations for Ukraine and the $300 billion that's left over in Western banks. And will that be used for the recovery of Ukraine? So in terms of transitional justice, which is just such an important issue, to what extent is that going to be caught up in the aftermath of the Russian-Ukraine war?
Well, to an extent that it's a question of prediction, I cannot tell, but to an extent that you're asking of my opinion whether it should be, yes, definitely it should be. Transitional justice should also address not only domestic crimes and abuses of the Russian government, but also its crimes committed as part of armed conflicts, both domestically and internationally. And we're speaking first and foremost about Ukraine, but not just Ukraine, but also Georgia, Syria, 2 Chechen wars. And it's important to remember again that it's the same culture of impunity or chain of impunity, as is stated in a recent memorial report, is something that perpetuates those crimes, especially during the armed conflicts that Russia has participated in. And just to remind you that Sergei Surovikin, who was at a certain point the head of the Russian army in Ukraine last year, began his career as a junior military officer whose battalion killed 3 protesters in downtown Moscow in August 1991 in the days of the coup. And rather than being prosecuted for that crime, he was pardoned. He was let off the hook by Boris Yeltsin and was even promoted. And that's how his career as a military commander started. So it seems like it's crucial to break this culture of impunity in the Russian armed forces. And certainly, war in Ukraine should be part of a comprehensive transitional justice agenda.
Nikolai.
I concur with what Grigory said, and want just to add that there is a declaration signed by many Russian lawyers called Brussels Declaration in favor of creation of an international tribunal for the crime of aggression. So this voice is already heard from Russia as well for such an initiative to address this crime.
Question right here.
Deborah Lyon, Federal Energy Regulatory Commission. Several years ago, I was the victim of a crime in St. Petersburg, and the crime was reported to the police, and the police came and investigated it. But all of my acquaintances in St. Petersburg told me not to expect anything from the investigation, that the criminal would be able to bribe his way out of any prosecution. Do you believe that bribery is an issue in the judicial system in Russia?
I didn't really hear.
Oh, she asks whether bribery is an issue in the Russian courts.
Bribery?
Bribery.
Bribery. Oh, that's a whole question.
The answer is yes.
Yes, but it's not as serious an issue as pressure from chairs of courts and the vertical, and the extent of corruption in the courts varies significantly with region. It's much more common in the South and in the Far East than it is in the North and West. But when it occurs, it tends to be more often in civil cases of high value. There's very little bribery at all in criminal cases because it simply doesn't work. You can get exposed. If you bribe and the judge acquits, then there'll almost certainly be an appeal. It'll go to higher levels of the investigation. It's just dangerous for everybody involved. And one of the other problems, even in civil cases, is if you want to bribe to get a certain result, you have to have enough money to pay for multiple levels of the system. You win, then it's appealed, then it's appealed again, and you've got a whole lot of different judges and court staff to deal with. In fact, studies of corruption in Russian court often show that much of the time the people who bribe they're not trying to get a particular result. They just want to avoid delay in the case, get it heard sooner. It's a problem, but not as great as you might think. And from all appearances, it's worse in Ukraine. This is one of the few things. The corruption in the courts is worse in Ukraine than in Russia. But if you take southern Russia near Ukraine, then it's exactly the same. So.
Let me just make one other point, that if you look outside of the criminal arena, if you look at civil cases and arbitrage cases, one of the things that I think most people don't understand is that a vast majority of the cases in Russia are debt collection cases, where there's actually no dispute at all between the parties, and they're handled through these summary procedures, and the amounts are trivial, right? So there's not really an incentive to bribe. And it's a puzzle for court scholars to understand why this debt collection continues in the courts. I mean, of course, you can bring whatever case you want, but it's quite inefficient in the sense that the outcome is already known. So,
Andre.
I have one observation and one question. Observation is such that almost each issue that has been discussed at this panel, as well as at previous panels, has not only something that we can discuss in future, but has already existed drafts or documents that have been prepared over last, for example, year or a couple of years by a number of organizations of Russian democratic opposition. Certainly, they are a different level of preparedness. But for example, the Congress of People's Deputies have prepared documents on almost each issue, like constitution, municipal self-government, bill of lustration, transitional jurisprudence, just almost each issue that have been touched upon. We have real documents that we can discuss, not only what we would like to see in those documents in future, but already documents that we can some kind of transform our discussions in more practical ways. Just what is included, what is right, maybe what should be added, what should be corrected, and so on. So that is why probably at next stages of such or similar conferences, we can discuss, we have much more practical discussion on those issues because we have documents. And my question would be to Nikolai, because Nikolai made quite a strong statement, as far as I understood, for some kind of personal justice against group justice or organization justice. And I have a question about that because we know that, for example, Nuremberg Tribunal had a very clear provisions about such organizations like Nazi Party, SS, Gestapo, and some other organizations of the totalitarian Nazi regime in Germany. We had the international legislation against such a terrorist organization like Al-Qaeda, ISIS. Many countries did undertake special legislation against Hamas as a terrorist organization. So why don't you think that such organizations like KGB, FSB, or some other organizations of the current regime, not only talking about the communist regime, should not fall into the same category?
Nikolai.
Thank you for your question. I think that we should specify what is the legal meaning of categorizing such organization. If you suggest sending any officer of FSB to jail based on a mere fact he used to work for this organization, I think it's impossible. And this precedent of Nuremberg Tribunal about SS, as far as I know, it doesn't have, it is not recognized in contemporary practice of international criminal courts. But if this is a ground for vetting, for illustration, I think it's possible, and it is widely spread in the context of post-communist transition in Central and Eastern Europe. And we can adopt such model. But my idea is that we should not vet everyone, even in these bodies. We should choose between those who were implicated in really severe violations of human rights from those who just, for example, served as border guards. You know that border guards are part of the FSB now. And it would be wise. The democratic government should not create numerous foes for itself. It's better to isolate those who are bad guys from general population. It's, of course, it's a political point, but also a legal one, because a law must be implemented, and it is implemented by the government and by the people.
Just for information, that just nobody sent each SS officer or Gestapo officer into camps after the 45, but the organizations have been disbanded and banned. Same story with the Baltic countries that banned FSB, KGB, all these organizations on the territory of those countries. It does not mean that every member who participated in this organization went to jail.
We have several online questions and lots of hands in the room as well. So We have a question from Max Gutbrod, who wants to who is asking to see what is the perspective of international cooperation. I do not so much mean the knowledge of other countries about which were impressive, but on comparing notes with other countries. For instance, under the helm of European law, Poland seems in the minute to start a transformation back to a more democratic regime. So to what extent is a international example can be used in Russia to deal with the problems of courts?
Well, you know, we have a long, sad history of doing legal development by trying to work on the models of other countries, and there aren't very many positive stories in that. It's a seductive idea because you think, oh, well, they're similar in this sort of way, and we could pick up this institution and we could institutionalize this kind of way of thinking. And to be honest, the changing of the institutions is the easy part. The hard part is the legal culture, trying to get people to understand the changes and to go and to be interested in them and to engage with them. I mean, the story that you told about how your friends were so completely convinced that the police would do nothing. There's not a law that we can pass that's going to change the way they think about the police, right? And that is what we really need is that kind of thing. And I don't know what the answer is. And maybe Poland is going to find the answer, and then we can build on that.
Yeah. Well, international pressure sometimes makes a difference. And of course, we have the story of various East European countries who joined the EU. The moment when there was the best leverage was actually when they were candidates for membership in the EU, before they got in. Once they got in, it didn't work as well. But now Poland, right now, in the last few years, of course, has gotten in trouble with the EU, and because it's actually had the guts to sanction Poland a bit, or at least to make threats of sanctions. So,
but the EU accession process is also very formalistic, and doesn't really deal with how people are engaging.
Oh no, I agree with you completely. I just thought the question was about international influence. I mean, and I agree with you that reform projects that go into a country, if it's just the people, the experts from the country of origin trying to promote what they think is a good, then they tend to fail. You have to, the people have to be sensitive enough to try to somehow create demand, to somehow put interesting ideas out there and have judges and other people in the countries respond to them. I went through all this in judicial reform projects in Russia, and even wrote an article about this. But
so we have several hands in the room.
Katya was the first.
I was Katya and Catherine. So we're going to take two at a time.
Yeah.
And short answers now.
Short answers.
Yes.
Thank you so much. When we watch the news, when we read judicial decisions, we feel that many Russian judges are a huge misfit for the office. Not only because they are poorly educated, not only because they are affected by their previous career, not only because they are professional deformation, but because they lack certain qualities which are absolutely necessary to make a good judge, and on the contrary, because they possess certain characteristics which prevent them from being good judges. So my question is, what do you think about the idea of psychological evaluation of candidates for judicial positions?
Anyone have a comment on that?
I do, actually. I was struck when I read a 2011 interview by a Constitutional Court Justice Gadis Gadjiev to Novaya Gazeta, where he was pressed on certain controversial decisions, judgments that he was part of on the court. And he said, well, at the end of the day, as a judge, you must be loyal to the state. If you're serving, you must be loyal to the state. And that exposes, I think it's a very telling quote, but it exposes the kind of judicial mentality that they have from top to bottom. They don't see themselves as independent actors, judges. They see themselves as part of the bureaucracy. And if I've been at the Constitutional Court hearings many times, and the way you would see judges shaking hands with, the representative of the president or the representative of the parliament tells it all, that they see themselves as part of one apparatus, and people appearing before courts, citizens, are outsiders in the system. So I completely agree. It's an enormous psychological, mental, philosophical problem that you cannot change with any law, like Katie said.
And I think maybe we need to distinguish between apex court judges, where there are certain different kinds of expectations on them, and then ordinary court judges. And here we're back to the discussion of yesterday, where we're talking about different traditions of law. I mean, judges are bureaucrats in civil law systems, right? They are not independent actors. They are not bred for courage or speaking out or anything like that. So it would, and I'm not one to say that whether that's right or wrong. It is what it is. And that's not true just in Russia, it's true across Europe. And that would be a much bigger change, to change the whole kind of what are we looking for in a judge. But I think the Constitutional Court judges are a different thing. Sorry.
Okay, no problem. Kathy Cosman, and right here then. We're going to go back to the two-question idea. Short question.
Kathy Cosman, retired. I have one short, simple question for Grigori. How many people inside Russia know that Putin is arguably the richest man in the world?
Okay, and right here.
Igor Slabik, Russian America for Democracy in Russia. Last session, we were discussing that it may not be a good idea to copy a practice from one country and implement in other country, but nevertheless, do you see any doctrines or practices from the US legal system to implement in future Russia?
Okay, you want to take a crack at Kathy's question? Local police. Okay.
Oh, I would say one thing to the question about practices, and I think it has to do with policing. One of the things that I think was meant to be good but has turned out to be bad is the time limits on police investigations, for example, whereby you create a system in which almost everything happens before the investigation is officially opened, so that they don't go over the strok, right? And so I think that while it was meant, I think, in really good ways, and from experience of other countries and that kind of thing, has really made it very challenging to make sure that procedural rules are properly followed, because almost everything is happening in the shadows in the time frame that is not related to that official opening of the case. That's just one small example, I think, of something where you could change around incentives quite significantly.
Okay, we have a question.
Question about
Putin and his wealth.
To be honest, I don't know why this question is being asked of me rather than anybody else on this panel or in this room. I can only say, well, more than 100 million people watched a movie called Palace for Putin, made by Navalny's Anti-Corruption Foundation, and the cost of that palace is estimated to be at about 100 billion rubles, which is about $1 billion.
Question in the back, and then the other question here.
Hello, my name is Elena Davlikanova, and I am with the Center for European Policy Analysis. I have two questions and one short comment. First question.
No comments, just two short questions.
Okay, two short questions. Question number one is about, do you know if Russian lawyers are engaged into the development of any mechanisms for further reparations for Ukraine? Because 375 billion that are frozen in assets are not enough. Ukraine has suffered more than 1 trillion by now. So are there any long-term mechanisms to ensure reparations? Second question, Russia has failed to restore justice for so many victims, both inside Russia and outside. What makes you think that this time there will be something that would favor these changes, given that even with the change of several people in Kremlin, the overall apparatus of oppression will remain? And just Yeah,
No,
about
no,
it's
just two questions
That's
is
perfect.
far, and then there was a question in the back. Right there.
Hello, my name is Andrea Mazaliu. I am from Freedom House. I'm a fellow there. My question relates to the relations or the prospect relations of Russia and the European Court of Human Rights. There is no more watchdogging Russia, infringement of the minimum standards of the European Convention of Human Rights. What do you think? Will it jeopardize the Russian judicial independence and, of course, ruling of the courts based on the standards of the European Convention on Human Rights?
Okay, who wants to take the Ukraine question on reparations and why you think that maybe Russia can change, and then the question on the European Court of Human Rights?
Well, let me start. I'm not aware of any particular reparation effort, in addition to what we are all already aware of. Why is it going to be different this time? No one is sure of that. My point is just if we don't try, it's not going to work. If we try, it might work. It might not work, but it might work, and that's why we should be working on that. One sign of hope that I see compared to what was 30 years ago is that at least in the Russian civil society, at least among ourselves, we can now see this consensus that there should be a comprehensive transitional justice agenda, including vetting, including lustration. If we look at what was 30 years ago, I mean, at the founding Congress of Memorial, 35 years ago, almost 35 years ago, in 1989, there was a resolution adopted saying that we should not proceed with any criminal prosecutions, quote, in the interests of humanity and mercy, unquote. I'm really glad that this attitude has changed, and we now have consensus, at least among ourselves, that transitional justice is a way forward. It's not going to work. Rule of law is not going to take hold in Russia without transitional justice. Speaking of the European Court of Human Rights, it's been already a tough relationship in the last years of Russia's membership in the Council of Europe. So many important judgments have not been implemented beyond payment of compensation. And some crucial decisions, like, for example, an interim measure ordering the Russian government to release Alexei Navalny, has not been complied with in 2021, all while Russia was still a member and it was formally obliged to implement those rulings. So certainly Russia's expulsion from the Council of Europe makes things even worse. What's left is the UN human rights system and institutions like the recently appointed United Nations Special Rapporteur on the human rights situation in Russia. It's not a judicial mechanism, but it's a naming and shaming mechanism that may have certain diplomatic consequences around the world.
Anyone else want to? Okay, next round of questions, right here and in the back there.
Thank you very much. Danila Galperovich, Voice of America. Bill, you almost stolen my question because in your question, you kind of connected transitional justice with the crimes of Russia and Ukraine. My question is more basic to whoever wants to answer. So what real judicial mechanisms for bringing Russia to accountability for these crimes you see now? Because we see International Criminal Court whose judges are prosecuted now in Russia. And we see independently UN court, and there are some lawyers who say that actually General Assembly could establish special tribunal as it was with Sierra Leone. So what real mechanisms you see to bring Russia to the accountability? Thank you.
We have a question in the back. There we go, yeah.
Спасибо. Спасибо большое. Меня зовут Павел Сулинзига.
Thank you very much. My name is Pavel Solenziga. I represent the Committee of the Indigenous People of Russia. I don't so much have a question. I just want to say thank you. Thank you for every presenter, but especially to Nikolai and Grigory. Grigory, I know personally, and we even work together. I think that if people have such people as Nikolai and Grigory, perhaps not everything is lost.
Okay. Other questions? Right here? Right here, he's right there.
A question for Dr. Hendley on the differentiation between educated people and lawyers in terms of their assessment of the courts. Couldn't at least a factor there be a psychological self-defense mechanism that your whole life isn't futility?
You mean if you're a lawyer? Yeah, if you're a lawyer. Yeah, I mean, but you would think that that would dissipate over time, right? That you would start to be more resentful. I mean, the thing that's interesting, and you can't know, right? I mean, you can't really, but you're right. I mean, that could be part of it. I certainly thought that my initial hypothesis was that the kind of the rosy glasses that you see in law students would not be present in the lawyers. So that's the question. But you know, that could be part of it as well. But it's an interesting finding, isn't it?
Okay. Okay. Repeat your question then?
No, his question was about Ukraine, right?
My question was about basic.
What tribunals are?
Yeah.
Yeah.
Realistic.
Yeah,
Mhm.
yeah, yeah,
Bringing Russia to responsibility.
yeah.
Well, it's a question, is it Russia? Is it Russian leaders? Is it, I was working with a colleague from Ukraine, a very good international law scholar this past year. She's a big proponent of creation of a new tribunal that would fill gaps left by the existing system. And I think she's got a lot of credibility, and this whole question, the landscape is not yet clear. There's still gaps, and in any case.
As you indicated in your question, there's a lot of mixed evidence on which work the best. That if you have a tribunal that isn't based in the country, then is there any legitimacy for that within the country? Do you really
That's
get the
another issue.
shaming that you want? But yet you do get some people put on trial, right? So there are many, many, many decisions that have to be made that haven't been made yet.
Yeah.
So.
Yeah, it's just too early to answer your question, really.
And for Ukraine, there are over 100,000 cases in Ukraine that have been documented and are basically ready to go, or to a certain extent ready to go. The only question is who will have jurisdiction over these types of cases, and whether just a Ukrainian tribunal will actually be able to evaluate and achieve justice for these crimes.
And whether or not they have the institutional capacity.
Yeah, exactly. Mm-hmm.
We do have an example in Germany when Cooney Foundation just brought 3 cases to German prosecution, and they did it. I mean, that's why I'm asking experienced lawyers, what do you think of all this mechanism? Which is most realistic? General Assembly, International Criminal Court, UN Criminal Court, and so on.
Yeah, that's pretty good.
Just briefly, and I'm sure you know about most of these procedures and proceedings. There's no silver bullet, there's no perfect mechanism, but there are many proceedings currently underway that include documenting the crimes, that include claims being made, and claims being heard. So there are proceedings at the International Court of Justice. In fact, 2 sets of proceedings: Ukraine versus Russia. There's an investigation at the ICC. There are several cases pending or being heard before the European Court of Human Rights, where Russia is still bound to answer because those relate to crimes committed before September 2022. And also, importantly, there's the United Nations International Independent Commission of Inquiry on Ukraine, which is active in collecting evidence of the crimes of this war. So these processes are going on. It doesn't mean, we should expect all perpetrators to be brought to justice, but it also doesn't mean there's a stalemate right now.
Question right here, in the back, middle.
Hello, my name is Irina Kapanitsa. I'm CEO of White Ribbon Movement in Ukraine. It's Prevention Domestic Violence, and we've been involved in developing the law on criminalization of domestic violence. So we're quite close with our courts and justice system. And my question is to Peter Solomon, just your statement about the level of corruption in Ukraine, that it's worse than in Russia. It's a bit like hurts me a bit. As international research, different show their index of corruption, showing index of perception of corruption in different spheres, and following them, Ukraine is much higher than Russia. And I just wanted to ask on which information your statement is made about this.
Well, fair enough. I mean, I guess my most important source is Maria Popova's work. Okay, her comparative article and book and so on. But whether this is completely, whether things have changed, for example, in the last 2 years is an interesting question.
Every few months it should be changed.
I mean, there's of course a huge effort to attack corruption in Ukraine. It's sponsored
talking just
by,
about comparing Russia and Ukraine, talking about level of corruption.
yeah, but that's not in general. I'm just saying in the courts, it appears. I mean, I wouldn't take a stand on this, and it's still, not. I'm not saying that every case in Ukraine that involves corruption. It's still primarily, in this case, cases heard by the Khazyaisny Sudi, very importantly, and there's a very interesting article about that too, about I'm trying to remember, I could find it for you later, about 2 tracks of handling of these business cases and situations.
Okay, I got you. Just you're not enough updated.
Yeah. I mean,
Okay, we're almost out of time. I have one last final question. We have all talked about the judiciary and the courts, but no one has talked about the procracy. And the procracy, quite frankly, is probably the most powerful institution and the longest running institution in Russian law. So to what extent do reforms of the procracy have to be done in order to change the Russian judicial system?
Well, that's a fine question, and of course we have there was a period of a serious attempt to reform the procracy in the early 90s, as you know quite well. I mean, there were, in fact, if you go back to the 1991 conception of judicial reform, which was the most serious critique of Russia, administration of justice in Russia, written by Sergei Pashin, Tamar Marshakova, a whole group of 9 people. That document presents the procracy as the main source of evil. I mean, in the system, in fact, it's an exaggerated indictment. But I mean, there were attempts to, but one of the ideas was reform ideas was you should eliminate all the procracy's supervisory roles, including general supervision, and in the end, all they did was eliminate 1 or 2 specific forms of supervision, and as I recall, in the '92 law, the procracy was banned from total fishing expeditions. They were supposed to be able to cite evidence that there was something going on somewhere before they leapt in. But I don't know. I mean, I'm sure you're right. The procracy has not only remained powerful, it's probably gained in power.
They're a very, very skilled infighter, aren't they?
Yes, they are.
That's a good way to put it. And you've written wonderful things about the procracy over the years.
Would you agree with that, Will?
Yes, they are. Yes, they are.
Yeah.
Okay. Well, with that, we're going to bring this discussion to a close. We're going to go now to a coffee break, and we will reconvene at 3:15 for our final panel on the constitutional parameters for Russia's future democratic transit. So, thank you, panel.
I think we would like to get started. So if you could please take your seats. If you could please take your seats. Thank you. Welcome to the final panel today. Obviously, a very important discussion about the constitutional parameters of the future Russian democratic transit. We have obviously a very distinguished, excellent panel here to speak. We'll have maybe 10 minutes of opening remarks from all our panelists, then they may want to talk to each other for a while, and then we will welcome questions both from the audience and to our online audience. If you have questions for our speakers, you can submit questions via email to kennan@wilsoncenter.org, via Twitter @Kennan Institute, or on the Kennan Institute's Facebook page at any time. Please include your name and affiliation when sending questions. So let me just introduce to you our final panel, although I think none of them need an introduction. They definitely will get one. Mikhail Khodorkovsky, as you know, was the former head of the Yukos Oil Company. He was a political prisoner for 10 years. He's obviously a leading member of the Russian opposition and organizing groups to think about the future there. Lev Ponomaryov is a persecuted Russian politician. He's a human rights activist. During the Perestroika period, he was one of the founders of the Memorial Human Rights Society. He worked with Andrei Sakharov during the elections for the People's Deputies of the USSR, and he has founded the Movement for Human Rights in Russia. Alexandra Vakru, next to him, is the executive director of the Davis Center for Russian and Eurasian Studies at Harvard University. She writes on Russian and Eurasian policy issues. She writes about the war in Ukraine. She's also the head of the master's program at the Davis Center, of which I was a graduate many moons ago. And so she has educated generations of young people in the field. Vasily Gatov, next to her, is a media analyst and journalist with 35 years of experience in Russian and foreign media. And he's a visiting scholar at the Annenberg School for Communication and Journalism in Southern California. And our own William Pomerantz, of course, whom you all know, is director of the Wilson Center's Kennan Institute. And you've been listening to him for the last 2 days. He's an expert on the complexities of political, economic developments in Russia. And of course, he's a legal scholar and a historian by training. So I look forward to everybody's remarks. And please, Mikhail Borisovich, would you start?
Приветствую вас. Я воспользуюсь тем, что здесь можно говорить.
I would like to welcome the participants, and I'd like to take advantage of the fact that I can speak Russian. Here, I think in the next 5 to 10 years, Putin's regime will expire on its own. It has to do with the fact that it's a personalized regime that's based on its founder, and once the founder is gone, it's not going to preserve itself in the way it has been under him. So the question is, what's next? What can we do? What do we do, and how can we do what we want and not what we don't want? And what needs to be done right now? Why is this question being asked by us, the democratic opposition of Russia? Why are we speaking about it in America? Well, this is how the situation has evolved. We ended up in a situation when the West, and the United States in particular, can apply pressure, maybe even substantive pressure, to the direction which the transit takes. And this influence will be formed not only when the transition starts in the future, but it also can happen now, ahead of time. So what are the items that we're looking at? Items of the agenda where the West and the United States can play a significant role. One is a choice between the monopolized power belonging to one person in the future, or a group, a distributed power, that it's going to be more distributed and more collective. This is already in the formation now. Whether it's going to, whether now, what is going now will survive, whether it's going to be a coalition or it's going to continue being a highly competitive situation when only one leader will emerge. So that is item number one, coalition versus one person. Number two, the opportunity to influence through canceling the sanctions or lifting the sanctions. Actually, the sanctions are being introduced and they will have to continue being introduced while the war is going on. But we need to be thinking about the time when it's going to be over and there will be time to lift the sanctions. What is going to be done in exchange? Is this going to be, for example, another strategic arms reduction treaty, which will be recalled, violated, and repealed, or it's going to be something else? And another example, which is probably not the last example, but this is something I'd like to stop at, acknowledging legitimacy. Putin is trying to prove that he is legitimate by creating the facade of adhering to a procedure. And that will depend not on how people will vote, because, of course, we know that there will be no voting, really, no elections. But it's going to depend on whether people will believe or not believe that the majority is for Putin. Well, and that's, of course, our internal affair. But whether the West will recognize or not recognize that Putin is a legitimate president at the end, in the long run, I think this issue can be resolved in different ways. So, for example, the Parliamentary Assembly of the Council of Europe passed a resolution in which they state that the next reiteration of Putin's term is not going to be legitimate. What others will say, time will show. So our task here is to convince the American political forces who are interested in the issues related to Russia, that the democratic of Russia is possible. It's not evident, but it is possible. And secondly, that the possibility of it is hinged upon what the US is going to be doing today. And it's also related to what America is going, and the West is going to do during the transition time, which will happen, as it always happens, unexpectedly, out of the blue. So those are, sincerely, I'm telling you about our agenda, and thank you very much for dedicating time to the issues pertaining to Russia here. I'm very happy that I'm very happy that I can continue the presentation. The fascist country. The fascist country that we are dealing with exists. Unfortunately, hundreds of thousands of people were killed And now is the time to stop the butchery, to stop the fascism, to stop the leader of fascism. What can we compare this situation with? Probably with the Second World War. How was this problem resolved at that time? In a good way, by the way. Germany ended up being a democratic state. It was done through occupation. It is very obvious that the occupation of Russia is impossible. That is not going to happen. So, well, then this is why we're all here. If the occupation is not possible, then the West needs to, well, doesn't need, it's up to it whether it's going to be doing it or not. It has to make huge efforts. It doesn't mean that there is no civil society in Russia. And it doesn't mean that they will not be doing anything, and therefore we don't need to be doing anything in the West. No. However, I would say that insofar the West has not taken effective measures. I have given you the example of occupation. Well, that doesn't work. Okay, I agree, but sanctions don't seem to be as effective either. So there is a suggestion, there is a proposal to show how incongruous everything is. Well, the bureaucrats in Russia, to a significant degree, continue spending their vacations in the NATO countries, not only just anywhere in the world, but also in the NATO countries. Imagine during the Second World War, would Hitler and his and people from his entourage spend their vacations like this? How do we stop that? Already we talked about this at the conference in Brussels. And by the way, I am speaking here on behalf of the initiative Sakharov Movement Group, инициативная группа Сахаровского движения. We would like to have sanctions for that would be tied up with a position that a bureaucrat is having in the system, whether it's a state councillor of the first or the second rank, the highest echelons of power. All those people are the pillars of Putin. So maybe not based on the personality, but based on the position he or she occupies, they should be sanctioned. So this way, the state system would start falling apart because people would start quitting, I think. And this is a very specific proposal that I have come to make here, and I have spoken with different people, including in US Congress. I think this problem can only be resolved in the US. In Europe, a lot of the countries there, and it's a little hard to make decisions with such multiplicity of voices. How is the power going to change in Russia? I think to imagine, it's very hard to imagine how things will happen. I was listening with great attention and interest presentations here on the transition period, but to imagine that it's going to happen and we will have the opportunity to use this transitional justice. I think it's not likely. More likely, there will be the situation when sanctions will be used the way I have described. Well, Mikhail Borisovich said 5 to 10 years. Well, I'm hoping that it's going to be sooner than that. Of course, Putin is hoping to preserve the preferences that he has in place. I think the government there will be some kind of turnover, okay? I'm not sure whether Putin will or will not be alive, how soon he will be alive. I think that we have observed some indicators of the fact that he's losing his absolute power. We know what happened to Prigozhin. We saw how lost Putin was when this humiliation happened from Prigozhin, and jokes about his coffin, about his corpse being in the refrigerator, and so on. If we had had such a rigid and terrible dictator, then maybe the actions would have been much faster and stronger than they were. So it is very hard to say how strong Putin is. Of course, he is strong. Of course, he is punishing his opponents in the most abominable ways, as we see with some of them who are incarcerated and detained in camps. Well, but we need to know that people who will come after him will be his successors who will agree with him. So where is the guarantee that that the new and more charismatic younger people are not going to make the situation even worse in Russia? So we have to say, we have to use the apple and orange, the carrots and sticks policy, the policy of sticks and carrots. In other words, we should be using these sanctions wisely, including economic. Okay, so what is the carrot and what is the stick? We should be giving them the promise of something positive coming out of certain little steps that they can take. Maybe this would help them to move closer to democratic elections.
And I think it should be the majority elections, something that happened under Gorbachev. I remember the 1990, I remember the movement Democratic Russia, and we won the election. It was a peaceful transfer of power in 1990. We had a peaceful democratic revolution. It sounds like a miracle, doesn't it? So perhaps a step-by-step process. And then later on, if we were to have the majority elections, then we have to have political parties. Mikhail Khodorkovsky says something very right. We should avoid a single leader. And one would understand that, of course, majority elections, like it happened under Gorbachev, where different groups nominated various people. A group of 500 people could already nominate one person. And everybody, all these nominees were equal. Perhaps my vision of future is a bit too optimistic. Nevertheless, I'll stop here and I'll give the microphone to my neighbor.
Thank you very much, Alexandra. Thank you, Angela. I'm going to maybe hew a little closer to the title of the panel, not. Oh, sorry. So it's an honor to be here with my fellow panelists. And I just want to make 3 comments based on what I heard today at the conference. The first is that the choices that were made when the 1993 Constitution was designed reflected, of course, the political situation at the time and the different political players. And as Ekaterina Mishina mentioned this morning, there's a certain degree of path dependence in which institutions evolve at any given time. It's important to think, therefore, that how the Constitution changes or is rewritten is also going to depend on who is going to be drafting it and what the political conditions are at the time. So, for example, the fact that we are all very concerned about the fact that the presidency or the executive branch is much more powerful than the other branches will definitely have an influence on how the next Constitution is drafted. And it's important to at least recognize the influence of the moment on the decisions that are made. I would also say that it's important to remember that the people who are interested in undermining documents or like regulations or like constitutions are usually the ones that are not in the room when the negotiations are taking place. So I remember when I was studying pharmaceutical corruption and markets in Russia in the 1990s, I would go and visit these different companies and they would say, oh, we have an entire room of lawyers. And as soon as a regulation comes out, we throw it into the den of lawyers and they figure out how to circumvent the rules.
The same will be true with the Constitution. And so it's extremely important that it's not only the same liberal-minded people that are behind the drafting and that are in the discussions, but that people really think about those who are not interested in the same objectives. The second point I would make is that Americans are so proud of their Constitution and their system of government. And in the 1990s, many people were convinced that if only other countries would adopt our wonderful Constitution and institutions, everything would turn out wonderfully. And what we have found in this country in the past, let's say, 5 to 10 years, is that in fact the effectiveness of the institutions depends on the willingness of the players that are in those institutions to observe the norms that underpin them. So it's fine to decide to determine and to design a constitution that has all of these important checks and balances, but it's also important to remember that you're relying on certain norms in order to make sure that those are observed, and that you have to anticipate, as Kathy Henley said in the previous panel, that there's no easy way to change the culture of the legal system or public opinion. And yet without those changes, it's very difficult to have the kind of country that you want based on the Constitution that you design. I would suggest, as an educator, that one of the best things that you could do to start changing that idea now is to make sure that there is access to online English classes as extensively as possible for anybody who has left Russia or is still in Russia. That's happening now, but not nearly to the extent that it should. Once people have access to sources of information, to academic journals, to newspapers, to different media outlets in other languages, they start to realize that there are systems beside their own that could be quite informative. And finally, the third point I would make is that we've concentrated a lot on separation of powers and how important it is, with good reason, also to some extent on the importance of individual rights. But I would also point out, or remind everybody who already knows, that federalism is also a critical aspect of the Constitution, and particularly in a system where opposition is so suppressed and so repressed in Russia, it might be that one of the best sources of a counterweight to a strong federal government is in fact finding ways to empower the regions that are part of the federal system. And so I would really urge those who are thinking about the next constitution or of the first aid kit, as Ekaterina mentioned, that a lot of attention be paid to how the regions can be really fully integrated into a system and provide some, let's not say opposition, but at least a counterweight to federal power. I'll leave it there.
Thank you.
Thank you. I would probably bring a grain of salt in all the discussions because, I mean, it's really kind of important to envision kind of the future great, beautiful Russia with a worthy constitution and respect to the rule of law and sufficient number of professionals who can implement everything and highly developed political culture and so on. And everything what I just listed is very questionable. So, well, taking from where Alexandra finished, I would say that first we need to realize that the parameters of future Russia, I mean, landscape, physical landscape, I mean, how much of Russia will remain Russia? How much of Russia will require to be Russia? The societal landscape, what is happening now with the consequences of mobilization of criminal elements. It's not going to be like smallpox or chickenpox, yeah? It will be, it's a cholera that will seriously damage the societal structure and will already bringing up sort of criminal structures much higher in the hierarchy of politicum than it ever was. The global status of Russia, what it will be after the war is ended one way or another. I mean, we all hope for victory of Ukraine and coalition that stands behind Ukraine, but it may well end in some kind of ceasefire that will be both both not beneficial for the Western side here, humiliating for Russian society because it didn't achieve the victory from their point of view, and there will be another wave of resentment and, well, everything bad what we can imagine about this. And also the biggest problem is that, and I think every sort of scholar who, well, not only studied law, but also social implications of Russia, know that Russia has a very particular, Russian people have very particular understanding of justice, not as a legal term, but справедливость, yeah? I mean, on all Russian polls, I mean, the most important thing Russians want is справедливость, which they interpret a very strange way, because it's not like justice for all, not solution for me. It's solution for me, and I don't care what happens with any other. And it's not because Russians are so egoist or selfish or atomized. It's just because there is no normal legal culture, and it never was, to be honest. The very short period under Alexander II should not be counted. One of the important lessons that I gathered from all the discussions of the conference is that we know very, very few things about minimal requirements of the future constitution. Minimal requirements which come from the parts of the society that can formulate what they want. We barely understand what politicum will be after kind of the conditions of change arise. We may kind of synthesize what elites will like, and probably kind of elites in what we know about them would like something like America. But we also have neighbors, and like half of our neighbors would like Russia to not exist at all. And some of our neighbors are still, I mean, of Russian neighbors are adversaries that not only want Russia not to exist, but Russia to be defeated and humiliated and parted. So this is not an easy set of conditions to To take into account and employ this new generation of lawyers. And they have not been forced, and they don't really want to be political anymore. They have been expert practitioners. Russia is going to change.
Россия изменится. Россия изменится. И авторы следующей Конституции
law and Western legal practices. And this is I think that a strong contingent of lawyers exist in Russia to actually do that. A couple other things that have to change in light of recent developments. I think in light of the 2020 amendments, which pushed Russia more to empire than the original constitution by saying that all Russians are basically a part of the Russian state abroad and asserting their power over Russians abroad. That has to change. That if Russia continues to perceive itself as an empire, then I think that Russia will face similar problems going forward, and that this imperial mindset has to be diminished. We also have the example of what is the Russian idea. And Boris Yeltsin actually had a competition about what was the Russian idea, and they basically decided that they couldn't find one. And they basically stopped the competition. But at some point, Russia has to figure out what it stands for. And it shouldn't be empire or statehood, but it should be some sort of positive values that they can envision going forward. The last thing I would just emphasize is that Putin recently put forward a new history course where he talked about Russia as its own civilization, and that it doesn't really have to deal with the West and other ideas. But if Russia is going to reform and to be a part of the global community and to be a modern society, then Russia can't see itself as its own distinct civilization, but it will have to figure out how it interacts in the global community and and so forth. So I think that for Russia to go forward, we will have to abandon this new course on statehood, which I think the books have just been written, but I don't think they will actually be really relevant going forward. Indeed, I think the course as outlined is just a new upward rendition of the history of state and law and the Communist Party. So, and I'm sure that it will not be received, it will be received as well as courses on Marxism, Leninism, and others. So for the future, I think we need to take advantage of the 50 years of new legal consciousness and new elements of Russian lawyers and jurists who have actually know about international law, have practiced international law, and I have, when I've interacted with all Russian lawyers in my practice and in Russia, I have always been impressed by their collegiality and their real expertise in law. And so that is the resource that we need to find and to expand on.
Thank you, Will. So I would like to ask a question of our three Russian participants on the panel. Earlier on today, I was on a Zoom call, and Denis Volkov from Levada was giving the latest results of their surveys. And it's very striking how passive the majority of the Russian population is today, how they've tuned out. If Putin and the Russian state
Насколько они перестали обращать внимание на Путина, насколько они, в общем-то, в последнее время как-то стали склоняться в сторону гедонизма и, ну, просто как бы блокируют происходящее для того, чтобы Россия перешла к более демократической структуре общества, для того, чтобы появилась новая конституция, потребуется, чтобы многие в России, многие ее жители и граждане, как это было при Горбачеве, стали более активными, как вот по мнению наших российских участников, с чего вообще нужно начинать вот, для того, чтобы добиться такого в процессе перехода или транзита.
Если я правильно понял вопрос, как добиться перехода в...
If I understood the question correctly, how to accomplish the transition, what to do?
Мы для себя понимаем, что транзит возможен по...
Well, we understand that the transition is possible on several directions. Either the transition will be happening inside Putin and his surroundings, in his entourage. The second is when this transition will happen in the street. But it's possible that they would be happening at the same time. In the first and in the second case, a lot will depend on how the oppositional democratic forces will treat this transition, how they would approach it. If they approach it from the standpoint of a revolutionary party, then the transition most likely will be authoritarian. If the transition will happen, if they will approach as a people's front, then I think it's more likely that the transition will be more democratic. I am completely in agreement with the fact that the key issue of balance is the regions. The regions are key, and the participation of regions in the process is very, very important. What I don't believe in is that somebody having obtained a power in his hands unilaterally, like single person. If a person obtains power in Russia, he is never or she will never share. This has happened only once in the history of our country, and I don't think the outcome was very good for the person who shared. Well, I would like to give an example of transition, the way it was happening in 1892. Why was it successful? And by the way, people were out in the streets. They didn't have arms, but the streets were full of people. Up to 1 million people would be out in the streets on the eve of the elections. Can this happen again? I would like to emphasize the role of the West, which is significant and cannot be overestimated. The Soviet power was falling apart gradually, bit by bit, and partially it was due to the information war, if you please, that was happening on the Western end, and it was broadcast to the whole of the Soviet Union. I started listening to those broadcasts when I was in the 10th grade, when I was in high school, so I knew where the truth was on what end. So I think informational pressure the counter-propaganda, I would call it counter-propaganda, should be happening. There are Democrats there. Maybe there aren't that many of them, maybe up to 25%. But we need to have a peaceful revolution. So the second point, we need to not only have the politicians define the situation, but the economic situation. That is a very important point. You know, people who were supporting the transition in the years I cover in my statement now, 89, 92, they understood that they cannot live like this anymore. So they had no option other than just go to the streets, take to the streets and try to accomplish something. So we need to include people. By the way, I was speaking with somebody who is a journalist and is working here, and he said, we have projects like this, and we need to have more information coming. There should be streaming, for example, via YouTube channel, where other channels. There should be other also cultural broadcasting, maybe some humor, some satire, political satire, and also maybe soap operas. You know, people really always liked to watch soap operas in Russia. Well, please start something like this as soon as possible. Because, you know, take somebody who is from the liberal circles, he watches this and he then will talk to the neighbor, and the neighbor will say, oh, wow, which soap opera? Tell me more about it. Because we need to attract the attention of up to 40% of Russian citizens so that they would provide, they would support for the peaceful transition. So this is what I think is important. And again, I'm emphasizing the role of the West is very important, informational pressure. We are doing everything we can on our end. We try to maintain constant contact and so on.
I would try kind of to answer your question, Angela, and suggest some ideas as well. Most of kind of passive or behavior or avoidance of agenda comes from two major sources. One is all of us know spiral of silence. Yeah, I mean, it's spiral of silence. And it's double spiral of silence, because on one hand, people are afraid, but they also kind of are being said what is correct to say. Yeah, so it kind of eats itself. The second important thing is that people are tired of bad news, really tired. And the alternative media, would it be US government funded or German government funded or British taxpayer funded or Russian in exile, generally conveys a negative agenda. An agenda that says, guys, your economy is in tatters, your country is disrespected, your soldiers are murderers, your commanders are criminals, your president is, well, worse than evil. And people just hide from that. They just don't want to hear that. I don't say that everyone. I mean, some people really kind of are in the bubble, and it's okay. But silent majority, they just don't want to hear it. And here I agree with Lev that there should be an alternative way of delivery of information and values that people would probably jump on. On the other hand, I don't believe that Russia could be crushed economically. It's not Soviet Union. With all the problems the country has, it is far from the condition Soviet Union was all the Brezhnev years. Yeah, And also, I mean, because it's a market economy, I mean, there are some very interesting effects that the war kind of delivered, like tremendous economic growth along the Transsib, which never been, I mean, since Alexander III, I mean, there was no economic growth there. Because, I mean, the country works to the east now. I mean, truck drivers went there. A lot of kind of border trade and logistics and so on. And I think that in a way, if we kind of want to address ordinary Russians, the agenda should be much broader than just Russia is condemned, Putin is criminal. And I think similarly on diplomatic front, with all understanding how difficult it would be, some issues remain critically important, like nuclear issues, further kind of strengthening of non-proliferation regime, especially assuming China wants to extend their nuclear arsenal. This is a perfect reason to speak with Russians about that. What do they think about that? What India thinks about that? What Russia and India think about that? What Pakistan thinks about that? So I would say that with all kind of understanding how awful current situation is, unfortunately, we shouldn't wait for Putin regime to collapse. We unfortunately need to interact, and probably that would also shorten the life of this regime. I mean, I don't know why, but I believe in that.
Can I just ask you, how would you interact with ordinary Russians?
Well, I mean, still YouTube is not banned, and you can do it there. Russians are pretty clever in accessing Instagram. It's still one of the largest platforms. TikTok is available. There are some alternative platforms developed to be able to reach Russians. Well, mostly it should be video. Well, of course, I mean, the greatest thing would be to clone Seven Novgorodtsov. I mean, but we don't have anything close to it now. He's too old, unfortunately. No, I mean, in University of Southern California, several months ago, there was a conference of Seva's role in the end of the Soviet Union, and he's definitely one of the few people who personally can be named in this list.
Okay, thank you. So I know, Will, you wanted to say something. I had a question for you and Alexandra. We heard that the United States will have a major role in what happens after Putin goes and there's a transition. I wonder whether you both agree with that, and how you think that the United States can in fact influence what happens. So I'll start with you, Will, since I think you wanted to talk.
Well, yeah. So we have experience with this, and it's not a really good experience. So I'm not optimistic that the U.S. During when we can't find consensus on aid to Ukraine, on a host of other issues, whether the U.S. will be willing to kind of create a new Marshall Plan for Russia, and will be wanting to actually engage in this. I don't see that as an actual possibility, or it will happen only after we deal with Ukraine. And I think we're going to be dealing with Ukraine for a long, long time. So I don't think the U.S. is really going to kind of take the lead. And the question is, will Europe invite Russia back? And I don't think Europe is in the mood to do that either. They have decided that they're not going to import oil and gas. They have decided that they're not a part of the Council of Europe. They're not a part of the European Court of Human Rights. the list goes on. So I don't think there's an appetite for Europe to immediately forgive Russia or engage with Russia. Obviously, there are reasons to do so in terms of nuclear weapons and national security, etc. But I don't think, I think Europe will be very circumspect when, after this conflict or whatever this event occurs, that they will not give Russia a free pass. That largely happened after the end of the Soviet Union.
Alexandra?
Yeah, I agree with Will. I don't think that there is a U.S. government policy solution that's going to come in and sort of make things better and extend American influence into Russia. I do think that there is the possibility to engage more soft power methods, which I think in the end are more productive because they don't undermine the Russians that are being that are cooperating with American universities, think tanks, negotiators, policies experts, and things like that. I would also not underestimate the extent to which business opportunities could play a critical role in reestablishing ties with a new Russia. So there's always been an interest in investing in Russia. Right now it's impossible and very unattractive, but people will come back, right? And once people come back, investors come back, they also want to have the kinds of official relationships that make investment more protected and the protection of property rights and things like that. And those might be the strongest advocates for real change than heavy-handed government policies or expecting a Marshall Plan, which I also agree is completely unrealistic. The other thing that's quite important is that one thing that you hear is that, okay, Russia is a hurricane right now, but China is climate change. And as soon as the situation with Ukraine is stabilized, right, and I think that that means also the situation in Russia is improved, there is a great willingness to go back to talking to Russia because China is still seen as a much more important threat. And I think that is actually going to be in the interests of Russia over the long term, maybe in the 5 or 10 years when the regime is changing.
Great, thank you. So now we have about a half hour for questions. I will remind people online, please submit questions for our speakers via email to kennan@wilsoncenter.org, via Twitter @KennanInstitute, or on our Facebook page at any time. Please include your name and affiliation when sending questions. So I think I see a hand up there. And I guess they're microphones, right? Yep.
Hi, concretely, by what year do you expect there to be a new constitution of the bright, wonderful Russia? And if I had asked you this question 2 years ago, in November 2021, before the full-scale invasion, how would your answer have been different? That is, in your estimation, did Putin's decision to invade Ukraine accelerate the eventual appearance of a bright Russia of the future, or did it put it further back?
Is it a question to me?
Yeah.
Everybody.
Okay.
Well,
So-
whoever would like to take it.
I'll start first. I don't have a year, but I think, as we've talked about the 2020 constitutional amendments, I think they were implemented in large part with Putin's invasion of Ukraine in mind. And so I think that the plan for Putin was that he was going to rely on the 2020 amendments, and that would be the constitution for Russia for a long time. So I don't think, I think basically he made those changes, and there were other changes that he introduced. The one I like least, but the notion of the Russian language as the language of the state-forming people really kind of said what Putin was going to do.
But in 2021, would you have said that the bright Russia of the future was closer or further away?
I would say it was further away. It was further away because Putin had made his plan known, and he was not going to actually implement, you know, positive, liberal legal reforms. He just wasn't going to do it. maybe others disagree.
No. I mean, just would probably give another argument to that. Yeah, I also don't have a year. I mean, technically, the person born in the male Russian person born in 1952 is likely to die in the next 4 or 5 years. I mean, biologically, it's kind of the most of
You said you weren't going to have bad news.
logical kind of logical. But again, I mean, the medicine is much better. He doesn't drink and so on. But the other thing, where Will is absolutely correct. I mean, making decision about Ukrainian war, making decision of further isolation of the country. Putin also weakened his regime, prospectively weakened. So I think I would put in 2021, I would put further in time. So he probably speeded up situation, but you never know how much.
Anyone else? Yeah, I think the fundamental question, right, is did the war hasten the decline of the regime, right? Is the end closer now than it was before the war? And I think that, for me, looking at the deep silence while Prigozhin was marching on Moscow, and the elite were trying to figure out how this was going to end, and their unwillingness to come forward and support Putin, suggests that the fragility of the system is more extensive than we had thought before. And so whereas it might have been fragile before, but not under as much pressure, right? Now, not only is it more fragile, but we also know that it's fragile. And I think that's where we begin to see that the end is possible.
Yeah.
Ну, видно, что уже другая волна пошла. Я согласен, что система...
I sense a different wave. I agree that the system is much more fragile after the start of the war. However, it would be very complex to predict the exact date of demise. I would say 2 or 3 years. I just would like to recall that a few days before the war, the whole world thought something different. I remember how Putin managed to convince everybody that there would be no war. And I remember that even the day before. When we say constitution, what kind of constitution are we talking about? If we are discussing the constitution of the democratic Russia, uniform for the whole territory, then the war moved this possibility further into the future. And I'm not sure whether it's going to happen within the next 20 years. One case in point, Germany. Imagine it, under occupation, denazification took 12 or 20 years. But if we are talking about differentiated, diverse Russia constitution, but Russia that lives according to a particular law and not under the dictatorship, then yes, that moment became closer. Because without a war, if Putin were to come up with a different way to stabilize his regime, maybe he could have stayed in power for 90 years until he was 90. But here, right now, we would say 5-10 years is the maximum.
Of Congress of People's Deputies. Firstly, I would like to thank Will and Pavel for putting this conference. I think it was very important, and I think it's a major milestone, what's happening here. But I have a question to Mikhail. When you were speaking, you mentioned the idea of the Popular Front and confronted it with the idea of the Revolutionary Party. And I would agree with the position that a Popular Front is always better. The question is how to construct it. And to my mind, in the opposition, the biggest problem is the problem of trust. Even when putting this conference, there were a lot of issues, and there were a lot of other events which there were issues. And people are always suspicious about each other, armed resistance versus non-violent resistance, insurgents versus elections, and this kind of things. To my mind, the only common denominator which could be is the legislature process. And that's why in the Congress of People's Deputies, we have everybody, all political parties of all times in Russia, which were ever in the parliament, even including United Russia, are represented there. Because it's about the text. And the text is always neutral, and the text doesn't give any questions to imagination. It's all written down there, and that's how we can proceed. What is for you the basis of uniting the Popular Front?
Я достаточно критически отношусь к
I am sufficiently critical about detailed texts because I remember 500 days of Grigory Yavlinsky. Life is always much more complex. I also, as you know, try to be very thorough when I teach myself and others to conduct coalitionary work, to work within a coalition. Because what is a coalition? Coalition is a collection of political representatives, and representatives do not like, or rather people who elected those representatives don't like to see their representatives next to other people whom they don't like. And this lack of patience and tolerance and inability to admit that we only face three tasks. First, to stop the war. Second, to change the regime. And three, to conduct honest and fair elections. And everything else is secondary, and everything else could be left for the next stage of discussion is not very easy to accept. Why? Because people want to discuss something that they like to discuss. Feminists would like to discuss feminism. The proponents of the climate change counteraction would like to discuss that. And as soon as we begin to speak about our common denominator, our unity begins to fall apart. And that's when we begin to say, yes, we all have our own diverse agenda. However, there is still a very important common agenda where we only have three goals: to stop the war, to change the regime, and three, to conduct fair elections. And sometimes it's so difficult to convince people to do just that. But I would like to thank your participants for your constructive position.
Thank you. This is a question to Lev Ponomaryov and perhaps to others. 2 points. One is for a country founded by communists, there's no mention of labor law or the rights of the laboring people, being somewhat formalized, to put it politely, which reminds me of something Ludmila Alexeyeva told me once, that the Moscow police force came to her, representatives obviously of the Moscow police, came to her to ask her assistance in helping them organize a trade union. I don't think the effort went anywhere, but I think it's significant in and of itself. And the other, of course, is the question of national minorities, which also has not been referred to at all. I believe, and I may be wrong, there are 168 ethnic minorities living in Russia today. Thank you.
Если я правильно понял вопрос.
If I understood your question correctly, your first question was the fact that the communist regime, and it was no accident that it was called totalitarian. It was a very hard bureaucratic mechanism of ruling the country. And no grassroots initiative was supported. And unions, labor unions, were called, there was even a slogan, The labor unions are a school of communism. Think of it, it's a contradiction in terms, and that's why the regime was called totalitarian. What could we say about it? And now about your minorities. Here's the story is somewhat different, because every initiative was nipped in the bud by the party and the government. Any attempts to preserve national language, national culture was perceived as a disturbance of the public order. Under the Soviet rule, these conflicts that concerned national problems did not appear. Why? Because everything was eradicated at the root. But we understand that every ethnic group would like to preserve their language, their culture, their memory, and that's why as soon as there was some freedom, people tried to resuscitate that, and that's when we started having problems. And besides, democracy is not an ideal system. In fact, there is no such thing as an ideal system. Perhaps democracy is the best out of the worst, because you manage to resolve the main issues without war, without weapons in your hands. У вас вопрос?
Could I ask you, everybody at the panel,
Could you identify yourself?
Andrei Larion of Center for Security Policy. Could I ask you about the elephant in the room that we're a little bit shy to talk about? Mikhail Khodorkovsky has mentioned in his remarks about the Putin's regime will go away. But it is very important how it will go away. Whether it will go away by itself, or it will be forced to go away. And after that, the discussion about the denazification of Germany that took more than 20 years after occupation of Germany. So that is why the critical question for any constitutional design critically depends on political landscape that would exist at that particular time. So the question is whether you can see free, democratic, law-abiding, federal, non-aggressive Russia, whatever, bright Russia, ever, without military defeat of Putin's regime.
Who would like to take this?
Okay. Ну, про то, как режим может...
First, about how the regime could leave, I have already mentioned, but I could also suggest reading my book, because I read everything, I wrote everything in detail. I spoke about the rather hard possibility. What I believe in a Russian federated, prosperous Russia, yes, I do believe in such Russia, in a very far removed future. But the prospect of 20 years, I see Russia as a very diverse nation, and that's why deeply federated. Some regions would be more democratic, others would be less democratic. Yet others would be more tribal in their nature, more clannish. And what would unite all of these different regions is the impossibility of breaking apart the infrastructure, the unwillingness to defund the standard of living, and also the understanding of external threats, because not everybody is as lucky as to live in a neighborhood with friendly neighbors. Now, the attempt to make Russia democratic, unified tomorrow, I believe could only lead to a dictatorship. because given the differentiation of different local communities, try to bring them to the same denominator could only be accomplished by federal bureaucracy. And you know that our federal bureaucracy tends to create a very hard, uncompromising vertical of power. And at the top, there would be a leader, and the leader always needs an external enemy. So a diverse development of a situation, I think, more probable. To what extent 20 years would be great. 40 years is more likely. It's a tactless question because we are all futurists. We're involved in futurism here. And I would like to cite an example that I have cited several times. Has country become more democratic after 1990? No. But at the same time, we've able to put in place a foundation by our constitution. And today, the critics of the regime say that the first two articles of the constitution are the best examples of constitution crafting. So that was some sort of a success. We managed to write these two articles. And what is a perfect democracy? Perhaps we don't know a single country with perfect democracy. We know that even the United States has its own host of issues. But I think that a few years would be required. And how do I think the power would evolve? I really think it would be an evolution, and a slow one at that. And it's not, the result is not going to be immediately democratic, but slowly the population of Russia, properly educated thanks to our actions inside of Russia, and I really count on the awareness campaign, on educational campaign. Slowly the population would slowly form a new understanding of how to enter Europe, how to become a European state. Yes, the gradual process would be taking place. But as our dissidents used to say, you need to do what needs to be done. You need to do what needs to be done and let it be. What happens will happen. I think that we should follow this principle.
The question of whether military defeat is required is an interesting one. I would say that, first of all, I don't know exactly what military defeat of Russia looks like, because perhaps even more important than what happens on the battlefield is the question of how Putin would be able to explain what happened on the battlefield to the population. So given the effectiveness of propaganda and the demobilization of the population over many years, my feeling is that he would probably be able to sell whatever outcome happens in Ukraine as being not a defeat, right? Maybe not a victory, but not a total defeat. I also think that the West is probably not going to support Ukraine to the point where a military defeat is possible. And therefore, orienting Russia's democratic future on that will be a distraction and keeps us from thinking of the other ways in which the democratic future is achievable.
Yeah. Well, I think yeah, the question about military defeat is more important than when and how. I've been prognosticating on the issues how the kind of this all can end and what scenarios will be for quite a while, almost 10 years since I wrote my first set of scenarios. It was funny, anecdotal, and more kind of on a humor way, but still kind of we can think of very well, quite a number of variants that would lead to regime change in Russia. But it
all of them are completely internal. I mean, it is impossible to imagine that anyone would risk bringing war onto territory of the country that has 1,600 nuclear weapons ready for use. But speaking about kind of military issue, of course, the arms race that Putin restarted gives us a feeling that it's kind of a 70s, 80s coming back. And while Russia will break its neck as Soviet Union did, we don't have understanding of this in full. I mean, we know that Putin lies a lot, and of course, people who report to Putin lie a lot. So we don't know whether this arms race is for sure, and probably people from intelligence community may say us more about that. But so far, I don't see kind of reasons to believe that arms race will break the neck of Putin's regime as well.
Well,
So I won't talk about the military issue, and I hesitate to talk about economic issues when I have a person who ran a multi-billion-dollar company and an economist in the room. But I will turn to the potential economic collapse of Russia. And I think that is also on the horizon as well because of sanctions. And when you look at the interest rates in Russia, the rise in inflation, that there's no access to capital, foreign capital markets, that gas is being basically being rationed in Russia. There's a whole host of economic issues that confront Putin and confront Russia as well. And I think that we need to consider over the slightly longish term whether sanctions and all this pressure on Russia will actually have an impact on Putin's ability to stay in power. And that at some point, I think that there could be a possibility that a sharp economic decline could have a dramatic impact on Putin's ability to stay in power.
I think we had a question. Yes, this lady.
Hello, my name is Elena Davlikanova. I'm with the Center for European Policy Analysis, and I'm Ukrainian. I would like to say that it is very important to discuss right now the changes, structural changes in Russia, institutional changes in Russia, but democracy needs Democrats. And whatever structures you build, if they are not filled with people who have certain values, these structures will never work in the right way. And I would like to share very quickly the results of the survey that I conducted voluntarily with a bunch of Ukrainian researchers this year. We asked Ukrainians if they had contacts with Russians, their relatives and friends, and there are almost 48% of Ukrainians who have relatives or friends in Russia. So whether they, what have they heard after the full-scale invasion from those people who are the people of Russia. And unfortunately, 85% of those who had such contacts, they heard Russian propaganda. So when your relative, when your close relatives repeats what has been said by Putin, what has been said by propagandists on Russian TV, it gives not much hope that Russian people are ready to support those values that you are talking about here. And if even tomorrow the dictator dies, conducting free and fair elections demands so many people with such values all over Russia who will be the part of election commission, watchdogs, those who count votes, and so on and so forth. So it's not only about the lack of repression, it's also about the ability and the readiness of these people to participate in all those processes. So,
Just say it.
And I would like to ask especially you about the messages that would work with these people who don't believe their relatives who say that, you know, what's going on, the truth is the truth. Because if we don't talk that Russia has to recognize its collective political responsibility, not only with regards to Ukrainians, but Chechens, Belarusians, Moldovans, and so many other nations. So if we don't build those messages, what are we talking with them about?
First and foremost, Russia should stop the war. I mean, should stop killing Ukrainians, killing its own people in Ukraine. That's the first thing. And what will Russia recognize and when and how is definitely not the first question, definitely. And as far as the opinions of population is concerned, we've seen, and I mean, Lev Alexandrovich and Mikhail Borisovich they're older than me. I mean, we've seen in 1982, the Soviet people who've been voting for нерушимый блок коммунистов и беспартийных in the numbers of 99.9%. Just in 3 years, they changed, and in 7 years, they elected съезд народных депутатов and then Верховный Совет РСФСР, which was the first free parliament. So people's opinion change, and propaganda is not the only thing that affects them. It's very easy to believe there is some Gammel, what is called flutist, who takes everybody and hypnotizes them. It's not like that. People choose a conformity because they understand that they are alone, even if they are in opposition to what happened. I don't know what messages will work. It needs constant checking. It needs constant change, and well, everybody tries it in many different organizations, starting from those existing in Ukraine to those existing in other countries that try to message Russians. I mean, collectively, massively, personal, and so on. One day it could come to fruition, and that's it.
Thank you. Well, I'm afraid we have run out of time now, so I'm going to turn it back to Director William Pomerantz for some closing remarks.
Well, I want to thank all of our panelists, both on this panel and the entire day, for just a very important and lively discussion. We have reached the end point, though, for our discussions on the Russian Constitution and democratic transit. And I'd like to thank all of our partners, the Khodorkovsky Foundation and the Institute of Modern Russia, for their excellent cooperation over the past 2 days of the conference. And thank all of the speakers again who have joined us here in Washington and virtually for a very fruitful set of discussions. I want to remind you that you can stay updated on our upcoming events and publications by visiting our website. And for those of you who are joining us today in person, I invite you now to our 4th floor for a light reception where you will have a chance to chat further with our speakers and other guests. So thank you all for coming.
And thank the panel, please.